we like to have for so do you want to set it up? Okay. Don't want to set that up after much. Yeah, it's great here.
Susan is different.
Like you can sit next to you.
And so she is a perfect resource for those days. I knew that was
All right, and we'll be starting promptly at 9. Before we go on the record, though, I just want to confirm a few details regarding speakers with council. Ms. Bass, you have the following people who will be speaking: yourself, Mr. Sandman, Ms. Dale, is it Ms. Dale? Okay. Mr. Simpson, Mr. Mayberry is speaking, okay. A representative from the Arizona Capital Representation Project, that's Mr. Mayberry. Emily Skinner. Okay, and a representative from the Arizona Center for Disability Law. Okay. And then you have 3 other people who are present but who will not be speaking, correct? Okay. Then we also have Dr. Toma and Mr. Foster who are going to be speaking, and their presentations will be virtual, correct? He's not going to speak. Okay. So may I recommend to you, but you certainly don't have to follow the recommendation, that we have Dr. Thomas speak last, and we take a break so that the, all of these high-tech people from ADOA who've been loaned to us, because we are not high-tech people, they can set up Dr. Thomas for you, and you can do a test to make sure you can hear him and he can hear you. Does that work?
Sure, well, so at the moment, we have Dr. Toma would be the third to last speaker. Is there a way to accommodate
I
that?
think that's fine.
Okay, thanks.
Oh, he's already on. Okay, well, that's how high-tech they are.
Excellent.
They're already ready. Okay,
Thanks,
all right. And that is all you have for speakers,
that's
correct?
right.
Okay. All right, and then on the state side, we have Ms. Dahl, Mr. Imbardino, and Mr. Sparks. Mr. Schneider is present but is not speaking, correct?
He is speaking.
Oh, he is speaking, okay. Everyone else I've noted so far is also speaking. Ms. Dahl? Everyone else that I've noted so far is also speaking, correct?
Possibly, it depends.
Okay, and then we also have victim representation. We have the victim who's present, Ms. Place for counsel, Ms. Singh from the Victim Advocate's Office, and Ms. Moody from the Victim Advocate's Office. All 4 of you will be speaking. Okay. Okay, great.
Mina, sorry.
All right, are we on the record, Annalisa?
Yes, ma'am.
All right, thank you. All right, good morning, everyone. This is a meeting of the Arizona Board of Executive Clemency. Today is Thursday, April 28th, 2022. The time is 9 a.m. This is the time set for the board to consider a recommendation for commutation of sentence or reprieve to Governor Ducey for Mr. Clarence Dixon, whose ABC number is 038977. As Mr. Dixon has informed this board through counsel that he does not wish to participate or be present for his clemency hearing today's date, which is his right, this hearing is being held at the board's office, which is located at 1645 West Jefferson in Phoenix, Arizona. The following board members are present and will be voting on the disposition of this case. I'll begin to my immediate right with the Honorable Mr. Sal Frenny. My name is Mina Mendez. I'm the board chair. To my immediate left is the Honorable Mr. Michael Johnson, and to my far left is the Honorable Mr. Luis Quinones. We'll just note again for the record that Mr. Dixon is not present for the hearing. His counsel indicated to this board both on April 22nd and again on April 25th that Mr. Dixon has made the decision not to appear. The board will therefore conduct the hearing in his absence. And Ms. Bass, I just wanted to confirm with you that that is still Mr. Dixon's position, that he does not wish to appear today.
It is.
Okay, all right. And as I indicated, that is his right to make that decision. We will note for the record the presence of counsel for Mr. Dixon. His lead counsel is Ms. Bass. She is joined by Carrie Sandman, Maren Dale, and Garrett Simpson. And Ms. Bass, did I identify all of the counsel representing Mr. Dixon?
Yes, you have.
Okay. Right, the state is also here represented by counsel. Lead counsel is Ms. Dahl, and she's joined by Mr. Schneider, Mr. Bordino, and Mr. Sparks. And Ms. Dahl, did I identify all counsel for the state?
Yes, I don't believe Mr. Sparks is here.
Will he be joining us later? Maybe, possibly, all right. And we will also note for the record the presence of the victim. I would ask the victim to forgive me for not using your name. I would like to use the names of victims publicly. Is it okay with you if I just refer to you as the victim? Thank you. All right. So
Ms. Mendez, can I just make one correction, please? I believe you said that I, Mr. Sandman, and Mr. Simpson are Mr. Dixon's counsel. That's not correct. Mr. Simpson's a witness today.
Okay.
Mr. Dixon's counsel is myself, Mr. Sandman, and Ms. Dale for
All right,
purposes
thank
of the
you for that
hearing.
correction, and we will note that as well on the
Thanks.
record. And Mr. Simpson's appearing as a speaker, not as counsel.
That's right.
All thank you. And we will note that the victim is present with counsel, Ms. Kleiss. All right. Is there anyone else here on behalf of the victim that I need to identify for the record?
No, thank you.
Okay. All right. I'm going to just identify and outline the procedure for the hearing on the record and for both sides. As the hearing lead, I'll provide a summary of the offense. Mr. Dixon's counsel will then present their case to the board. The board may have questions for counsel or for any speakers presented by counsel on behalf of Mr. Dixon. Following the submission of Mr. Dixon's case, we will hear from the state. The board may have questions for counsel for the state or any of the speakers presented by the state. Then the victim and the victim's counsel will present any information that they wish to have considered. Finally, Mr. Dixon's counsel will be given an opportunity to present any final statements to the board. The board will then be going into discussion on the issues of commutation and reprieve, and at the conclusion of that discussion, the board will vote. Each side will have 3 hours to address the board. You are each responsible for keeping track of your own time. We will be taking a 10-minute morning break and a 10-minute afternoon break, as well as a 45-minute lunch break. I am asking the public who are here observing today, we do have a very full house. If you would please, if you are not a participant in the hearing, if you could please refrain from using the public restroom during the 2 10-minute breaks to allow counsel and participants and board staff to use the restroom without creating a delay in the hearing. And then the public could wait to use the restrooms until we resume the hearing again. We would appreciate that accommodation so that we don't have any delays. Council participants and any members of the public are placed on notice that while you do have the right under the Arizona Open Meeting Laws to be present and to listen to these proceedings, there is no right to disrupt the proceedings. Due to the serious nature of this hearing and the constitutional rights at issue, disruptions will not be tolerated. Any person who engages in disruptive behavior at any time during the hearing will be asked to leave the boardroom. We also ask that the participating parties assist us in creating a good record of the hearing by speaking clearly when you are called upon to speak, making sure that your microphone is turned on when speaking and turned off when you are not speaking to minimize background noise. As a reminder, the board will not be taking public comments today. However, we did receive a large volume of written public comments which each board member has reviewed. For those who are here observing in the boardroom, please remain as quiet as possible during the hearing. Turn off or silence all cell phones, refrain from talking, and try to avoid rustling papers so that we will have a good, clear record of the proceeding. If you must engage in conversation with another person, we would just ask that you please step out to the lobby to do so. And I want to thank everyone for adhering to those requests. All right, Ms. Bass, are there any preliminary matters that we need to address before we begin with the hearing?
No, they're not.
Ms. Dahl?
Mayor.
Okay. All right, I will now provide a summary of the offense. On January 6, 1978, the victim, Dina Bowden, a 21-year-old student and senior at ASU, had dinner with her parents and then met up with a female friend at a nearby bar. The two arrived at the bar at 9 p.m. that evening and stayed until approximately 12:30 a.m., at which point Dina told her friend that she was going home and drove away alone. Dina and her boyfriend lived in a Tempe apartment. Her boyfriend returned home to the apartment at about 2 a.m. after spending the evening with his brother. He entered the apartment and found Dina dead on the bed. She had been strangled with a belt, and she had been stabbed several times. Investigators found semen in Dina's vagina and on her underwear, but could not match the resulting DNA profile to any suspect at that time. In 2001, a cold case police detective checked the DNA profile against a national database and found that the DNA profile matched that of Clarence Dixon, who at that time was an inmate at the Arizona Department of Corrections. Mr. Dixon at that time was serving multiple life sentences for kidnapping, sexual abuse, and multiple counts of sexual assault for offenses committed June 10, 1985 in CR 001-1654. Further investigation revealed that Mr. Dixon had lived across the street from Dina at the time of the murder. None of Dina's friends or family knew of any previous contact between the victim and Mr. Dixon. At this time, I'm going to turn it over to Ms. Bass. And I'm going to remind both counsel during your presentation to address both the request for commutation and the request for reprieve in your presentations.
Okay.
All right, Ms. Bass?
Thank you, and good morning. My name is Amanda Bass, and I am an assistant federal public defender. Together with my colleagues here with me today, I represent Mr. Clarence Wayne Dixon. At the outset, I'd just like to preserve for the record my objection to these proceedings before this board, which is constituted in our view in violation of Arizona law. We're proceeding today in order to preserve Mr. Dixon's right to seek executive clemency, but we are doing so subject to the foregoing objection. I also want to acknowledge the profound pain and suffering that has brought us here today as a result of Dina Bowden's senseless and brutal murder. In 1978, she was in the prime of her life, and she was a student at ASU when she was sexually assaulted and murdered within what was supposed to be the safety of her own home. Ms. Bowden and the many, many people who loved her were robbed of her life, and they were also robbed of the many contributions that she would have undoubtedly made to her community. We are not here today to dispute Clarence Dixon's guilt of her murder. nor are we here today to somehow justify, excuse, or minimize the Bowden family's suffering as a result of her tragic death. Rather, we are here today to ask this board for mercy. Mercy because Clarence's need for intervention and treatment as a damaged and profoundly mentally ill young man went unmet. Mercy because the system that was tasked with deciding whether he deserved to live or die was fundamentally broken. And mercy because at this point, 44 years after Miss Bowden's tragic murder, Clarence is a frail, blind, elderly, and mentally incompetent man whose health is rapidly failing him. You have been provided with and are going to receive today information supporting our request for mercy that the jurors who voted to sentence Clarence to death were never able to consider. For example, the jury never knew that in 1977, when Clarence was 21 years old and himself a student at ASU, he was diagnosed with schizophrenia and was in the early stages of that psychotic disorder's onset. The jury also didn't know that in the months prior to Miss Bowden's murder, Clarence was found mentally incompetent. He was committed to the Arizona State Hospital, and while he was there, he was prescribed antipsychotic medication. Jurors also never knew that former United States Supreme Court Justice Sandra Day O'Connor, who in 1978 was a trial judge right here in Maricopa County, determined that Clarence was legally insane, and just 2 days before Miss Bowden's death, ordered the Maricopa County Attorney's Office to commence civil commitment proceedings so that he could be committed to the Arizona State Hospital. Judge O'Connor made that order precisely because she recognized that Clarence was severely mentally ill, that he presented a danger to himself and others, and that he needed intervention. Today, the Maricopa County Attorney's Office is here to urge you to send Clarence to his death. And yet, ironically, that is the same office that in 1978 ignored Judge O'Connor's orders and never bothered to initiate proceedings that could have resulted in Clarence's commitment to the state hospital. The jury didn't know any of this. The jury also never heard about the chronic abuse and neglect that Clarence endured throughout his childhood, or about the impact that had on his development. The jury never knew any of this because, as a direct function of Clarence's serious mental illness, he fired his lawyers, he represented himself on trial for his life, and he was simply not equipped to give the jury all of the information that it needed to make an informed and fair decision about his punishment. We know, because one juror has said so, that had the jury been given all of this information, it would have been considered and it could have made the critical difference. Today, our hope is to provide you with a more complete understanding of just how we got to this point. My colleague, Carrie Sandman, will walk you through how a capital case moves through the state and federal court system, from trial through the appellate, post-conviction, and federal habeas processes. You are also going to hear from Mr. Garrett Simpson, who is a veteran capital defense attorney here in Maricopa County, who represented Clarence initially in his capital case. He will tell you about his inability to rationally communicate with Clarence. He'll describe for you how it was possible that Clarence was allowed to represent himself, going up against veteran capital prosecutor Juan Martinez, despite the clear indicia of Clarence's mental illness and mental incompetency to do so. Ty Mayberry, a mitigation specialist who was assigned to help Clarence as he struggled to represent himself, and who was present throughout the trial, will describe for you Clarence's struggles navigating the legal system and his inability to adequately defend himself as someone suffering from serious mental illness and who was also mounting his defense from the confines of the county jail. Dr. John Toma will also walk you through Clarence's longstanding history of serious mental illness, and he will describe for you the neglect and the abuse that Clarence endured throughout his childhood and which had a devastating toll on his development. My colleague Marin Dale is going to provide you with information about the growing movement in states across the country away from executing the seriously mentally ill, especially in light of concerns around how untreated mental illness impacts a person's moral culpability, their ability to protect their rights in the legal process, and the penological justifications for imposing the ultimate punishment. And finally, Emily Skinner will address additional systemic breakdowns in the process that led to Clarence's capital prosecution and his death sentence, including his virtual abandonment by the advisory lawyers who were supposed to help him. And she will speak to the sovereign Navajo Nation's call for this board to extend mercy to Clarence in keeping with Navajo cultural beliefs. There are many who will urge you today and who have urged you to believe that none of this context matters, that you should respect the jury's verdict, and that you can feel confident that Clarence deserves to die because the state and federal courts did not spare him. But what they won't say, and what we hope to show you, is that once a person is convicted and sentenced to death, it is often very, very difficult for courts to undo that fact. And that's because of strict standards of review and rules around procedural default, waiver, and deference that apply on appeal and in post-conviction proceedings that prevent the courts oftentimes from intervening even when it's clear that a death sentence may be manifestly unjust. It's precisely because of those limitations on the court's ability to act that executive clemency, these proceedings, exist as a fundamental part of the American system of justice to correct the system's failures and to right wrongs by showing mercy. I'd like to now turn it over to my colleague, Carrie Sandman, who is going to walk you through the state appellate, post-conviction, and federal habeas process. Thank you.
You know, I want to say at the outset, as a parent and a grandparent, I join in Ms. Bass' sentiments that she expressed to you this morning about the loss of Deanna Bowden and the tragedy that befell her family. It's something that I think we all feel very deeply, and we want to emphasize that as we go through this process this morning. I want to talk a little bit about the history of clemency first off, a recent history of clemency and commutation in capital cases, because it differs so substantially from the board's task in the ordinary course of its duties when the decision is whether and when to release a prisoner back in the community. In death penalty cases, commutation is nearly always a fail-safe. It is usually recommended in a capital case in those cases where a jury has never heard the evidence that provides the basis for commutation. There's the recent example of Mr. Jones in Oklahoma, where Governor Stitt recently commuted a sentence to life without parole, where there were questions of innocence. There was a case a couple of years back in Virginia, where the governor commuted the sentence of a man who was severely mentally ill at the time of his crime, but the jury wasn't aware of that evidence. The governor in Ohio has, in several cases, the current governor, I think it's the prior governor as well, where jurors hadn't learned of a severe mental illness that contributed to the crime. So not surprisingly, what you're here today is evidence that not only the jury did not hear, but no subsequent court ever considered in determining the justice of Mr. Dixon's sentence. And I suspect, as Ms. Bass said, you'll hear some voices today urging that Mr. Dixon's jury's decision be given respect and carried out. But I would posit there's no tension between recommending commutation while at the same time respecting the limited context in which a jury issued its verdict, especially when the jury never had the opportunity to consider the evidence presented to this board. And as we know, the jury is intended to be the conscience of the community. I recognize that, but it really rarely is in a capital case. Why? Because those members of the community, and there are many, who are unwilling to impose capital punishment based on religious or moral grounds, are not permitted to serve on a jury in a capital case. And at least at the time of Mr. Dixon's trial, if the prosecution even suspected a potential juror had some concerns about the death penalty, there would have been plenty of opportunities to strike them from the panel. But beyond that, let's look at what Mr. Dixon's jury heard and what they should have heard. What they really should have heard was a plea of guilty but insane and a plea for mercy based on his mental illness. That never happened. Jury research has consistently demonstrated now over many decades that jurors are reluctant to impose the death penalty when they believe a defendant's mental illness was a contributing factor in the commission of crime. And in this case, crimes, because there were other crimes before Ms. Bowden's murder. Here, the jurors knew nothing about Mr. Dixon's mental illness. And it is really undisputable that at the time of Ms. Bowden's murder, Mr. Dixon was seriously mentally ill. Just hours, as Ms. Bass mentioned, hours before Ms. Bowden's murder, then Maricopa County Superior Court Judge Sandra Day O'Connor, sitting as a judge, concluded that Mr. Dixon was so mentally ill and dangerous to the community that he should be civilly committed. Coincidentally, you'll hear that Mr. Simpson was actually a bailiff for Judge O'Connor in that time frame. I believe perhaps either a little before or after this happened. And for those of us who have been in Arizona a long time, and I've been here over 46 years, who know Judge O'Connor, if she had one thing, she had wisdom. We like to think all judges have that. They all do to some degree, but I think that in my experience, she had exceptional wisdom, and she knew something about Clarence Dixon on the day that she found him not guilty by reason of insanity. And she did what she could do in her limited power at that time to take steps to protect the community. And tragically, that never happened. So we have this trial, and he's obviously rapidly convicted and nearly as rapidly sentenced to death by a jury that really didn't know anything about him. And so the question is, well, what could really be done about that in the courts? So let's start with the Arizona Supreme Court, because that's, in a capital case, you go from your trial verdict to the Arizona Supreme Court on a direct appeal. And a direct appeal review is limited to the record before that court. So in other words, in the exercise of its review of the case and whether Mr. Dixon received a just sentence, that court was limited to the evidence presented to the jury. It wouldn't matter. I mean, none of the evidence that you're going to hear today is something that a direct appeal court can consider. They can look at the trial record and say, based on that evidence, did the jury reach a correct verdict? And in this case, we know the answer to that. And that sentence was affirmed, as well as his conviction. The next stage in a capital case is a state post-conviction case. Once the Arizona Supreme Court decides, affirms a death sentence, it automatically goes into state post-conviction. And the judge in that case was the same judge who was the trial judge, who allowed Mr. Dixon to represent himself. And what you're going to hear eventually from Mr. Simpson, who was his lawyer when the decision was made that Mr. Dixon would represent himself, is that Mr. Simpson didn't inform the court, as he will tell you that he should have, about Mr. Dixon's inability to represent himself. Nevertheless, in state post-conviction, the big issue was Mr. Simpson ineffective in allowing, sort of standing by and saying nothing, as the trial court made an evaluation with respect to whether Mr. Dixon could represent himself in a capital case, which, even without having heard anything we said about Mr. Dixon, is crazy. To represent yourself in a capital case of this nature makes no sense. Nevertheless, the trial court found he was competent to represent himself, and he did. Now, in state post-conviction, there was only one way to, what I would say, is correct the error being, well, the jury never got to hear any of this mitigation evidence. What do we do about that? There was really only one way to remedy that, and that was to argue that Mr. Simpson was ineffective, that Mr. Dixon should have had a competency evaluation by a psychiatrist, one or more psychiatrists, before the decision was made to allow him to represent himself. And the trial judge said, you know, I saw Mr. Dixon, he handled himself well at the trial, and I think he was competent, and that's the end of that. So in state post-conviction, there was never any question or consideration about the justice of the death sentence in light of this mental health evidence. The door got shut immediately when the trial court said, well, Mr. Dixon's fault, he decided to represent himself. So there wasn't an opportunity for any judicial officer to say, well, wait a minute, jury never heard this, would it have made a difference? That didn't happen in the state post-conviction proceeding. The next stage in a capital case is a federal habeas case. It was actually at that point that our office was appointed to represent Mr. Dixon. In 1996, Congress passed a law, the acronym for which is the EDPA law, which severely limited the power of the federal courts to review state court decisions. And I'm not here today to contest the wisdom of that law. The law is what it is. The law, as interpreted by the United States Supreme Court, means that even when a federal court disagrees with a state court decision, even when a federal court thinks that the decision was wrong, that's not sufficient to overturn a state court decision. And again, I'm not saying whether that's good or bad, but it's explanatory to how we get where we are today. You essentially, to get relief in a habeas case, is you have to show that no reasonable judge anywhere would have done what the state court judge did. That's something that the U.S. Supreme Court has said. You got to show it's way more than just a wrong decision. So in the federal habeas, the only thing the federal habeas court could review that has real relevance to what we're talking about here today is the state post-conviction court's decision. I thought Mr. Dixon was competent. I saw him in the courtroom. He looked good enough to me. And when the state post-conviction court made that decision, it made it in the face of uncontradicted evidence from Dr. Toma, who's going to testify here today, and Dr. Romesco Patino, who is a psychiatrist here in Maricopa County. Both of those doctors provided affidavits after they examined Mr. Dixon at length that demonstrated that Mr. Dixon was not competent to make the decision to represent himself or to represent himself. But once this case goes to federal court, those judges can't consider Dr. Toma and Dr. Romesco Patino because they are bound to uphold the state post-conviction court's view in that case, whether they thought it was a good decision or a bad decision. They have very limited flexibility to review it. And so, as in the state courts, the federal courts never considered the propriety of Mr. Dixon's sentence in light of the mental health evidence that we have. Everything that you now know about what Justice O'Connor did, evidence that you'll hear later from Dr. Toma, nobody ever considered that. And that's why, as I said initially, that commutation serves an important purpose because, and this is not unique to Mr. Dixon's case. I've talked about cases where boards have recommended clemency based on new evidence, but on many, many occasions, clemency boards are the only body that ever hears the defendant's side of the case. And that's the way our system works. For better or for worse, it becomes an important fail-safe that we play. Thank you.
If there are no questions, we will move to the section of our presentation where we will ask for a commutation.
Yes, I actually have a question for Mr. Salmon. Can you explain to the board the standard that the courts must apply and find to determine whether a person is competent to represent themselves?
You know, the standard is very similar. The standard as to whether you can represent yourself is very similar to the standard for competency to stand trial. So you have to have, I mean, the first step is to ask if they really even have a rational capability to communicate with their lawyer. Because that's the reason that he wants to represent himself. And, you know, people have disagreements with their lawyers all the time, deservedly in many instances. But in a competency case, the question is whether can they rationally communicate with their lawyer. And I think Mr. Simpson will tell you that he had no ability to do that. And Mr. Dixon believed that he was wrongfully arrested in 1985 by the Northern Arizona Police Department, which was completely false. There are, you know, we know there are records that show which police agency arrests you. He insisted that because of that, he never should have been convicted and gotten a life sentence. He never should have been imprisoned to have the DNA tested. He insisted that Mr. Simpson argue that in court. Mr. Simpson, you know, wrote him a long letter documenting who arrested him. He documented how many times Mr. Dixon had raised this very same issue before he was ever arrested for his violence murder. He had raised this issue in multiple courts and been rejected. And when Mr. Simpson told him I can't ethically raise a frivolous claim, Mr. Dixon fired him. And there was no he lacked the rational ability to communicate with his own lawyer, and that is a touchstone for incompetency to stand trial. And so what should have happened, and I have the greatest respect for my friend, Mr. Simpson, as he knows, but what should have happened is that Mr. Dixon's competency to stand trial should have been examined immediately by psychiatrists appointed by the court, because the first step in the process is to answer that question. And if the answer is he's not competent to stand trial, he's certainly not going to be competent to waive counsel and represent himself. And that's where this whole thing sort of, the trapdoor opened, and it's remained closed ever since. And to this day, Mr. Dixon, on a pro per basis, is insisting that he was wrongfully arrested in this case by a police department that never arrested him, that for that reason, all this should just go away.
And we've, Mr. Salmon, we've read all of those records, all of the court records. To me, it seemed like the finding made by Judge Klein at the time was that there was a disagreement between Mr. Dixon and his counsel about trying to make the facts in his case fit this case that had said that certain entities are not considered law enforcement, that they don't have arrest power and things of that nature. And I don't recall the name of the case as Brood or something like that. But it seemed to me from reading the record that Judge Klein did go through that legal analysis and did find that while he disagreed with his lawyer, that it was not based on any lack of confidence on his part. It was based on a disagreement about the case law, which, I mean, even lawyers disagree about case law interpretation, and even lawyers will stretch to make facts fit a case when it really doesn't. I mean, I was on the bench for almost 10 years. That's not uncommon for lawyers to do that. So why don't you spend a little time telling the board what your position is about that and Judge Klein's findings?
Both can be true. I think what I would say is that Judge Klein was absolutely right that there was a disagreement. But that stops, so that's not wrong, but it stops short of the deeper analysis of what happened here. Because yes, there was a disagreement, but Mr. Simpson never informed Judge Klein at the appropriate time. And Judge Klein made the decision to allow Mr. Dixon to represent himself, that Mr. Dixon was unable to communicate with his attorney rationally, applying the test for competency to stand trial. And Judge Klein's decision was affirmed by the federal courts, by the federal district court, by the Ninth Circuit. But as I said, those courts have very limited power of review. And even putting aside, if we were all to agree that Judge Klein was right, that Mr. Dixon, let alone anybody in a capital case, was made an adequate decision to represent himself in this case, it leaves us in the same place that we are here, where we are today, which is that no court had, the jury and the courts who have along the way affirmed his sentence did not have an opportunity to weigh the scope and breadth of his mitigation evidence and ask whether that should make a difference to the outcome. It is only this body, through all the appeals that we've talked about, that is being asked to do that. And of course, you will make whatever decision that you think is the right decision. But
Is your argument that, it was a little bit unclear from the documents presented to the board, is your argument that Mr. Dixon was incompetent at the time that he committed the murder, or at the time that he represented himself in trial, or that he's incompetent now and unable to understand that he is scheduled for execution and why? Or is it that he's always been incompetent?
We certainly believe that there is substantial evidence that he was severely mentally ill at the time of the crime. Excuse me. So that, when we talk about his mental illness at the time of the crime, we're really not talking about competency. We're talking about what would a jury have done with that information. And of course, in Arizona, it takes one juror to spare a life. And we know from decades of research of capital juries that mental illness at a time of a crime is the most compelling evidence to jurors in a capital case. So that's the evidence of his mental state at the time of crime goes to that. Yes, as to competency to stand trial, it is our position that he was not competent to stand trial. And by virtue of that, he was not competent to represent himself. Now, Judge Klein disagreed with that. We know that. As to his competency today, he continues to believe, just as he did 20 years ago, that this is all going to work out for him. Yeah, he was arrested by the university police, which of course is not true. He believes that. He believes that, and to that extent, I mean, he still has schizophrenia. It's not a curable disease. He doesn't have a rational understanding of the state's reasons for executing him. He knows, I think, that he is sentenced to death and that on May 11th, his execution is scheduled. But his focus is on the wrongful arrest. He has a lot of issues around paranoia and conspiracies as to why no one's really believing that or taking, maybe they do believe it, but they're not taking action on it. So there's a gap there. And we have filed a motion in the Pinal Superior Court that's, is it Judge Collins? Olson. I'm
Judge
sorry.
Olson.
That's pending before Judge Olson. And Judge Olson has reviewed the papers. Earlier this month, he granted a hearing finding that we had set out a prima facie case that Mr. Dixon was incompetent to be executed. The state of Arizona filed a special action to the Arizona Supreme Court. The Arizona Supreme Court directed Judge Olson to reconsider his decision. Strong message there. Judge Olson last evening reconsidered his decision and found that there still was prima facie evidence that Mr. Dixon is incompetent to be executed.
And if I could just interrupt.
And we have a hearing coming up next week.
If I can just interrupt, and that's on May 3rd, right?
Yes, ma'am.
The Supreme Court remanded it to Judge Olson to reconsider because he had made that ruling prior to receiving the state's position, right?
Right.
And he subsequently ruled the same way after reviewing the
He did last evening, yes.
statements. Okay. Why didn't the jury hear any of the mitigating evidence? Because there was a discussion of that in the trial record that we all received and reviewed, where Judge Klein engaged in this discussion with Mr. Dixon about him having had, something like 4 years to gather and present mitigating evidence that the decision was made not to present that evidence. So why didn't the jury get to hear
Do you mind if I?
If I could respond to that. So first, that colloquy was not before the jury. That was in the context of Judge Klein determining whether or not Mr. Dixon warranted an additional continuance of the trial so that he could develop and work with someone who you will hear from today, Mr. Ty Mabry, to try to develop and get his mitigation evidence ready to present to the jury. So what was being discussed in that context was one outside of the presence of the jury, and it was about, the haphazard state of Mr. Dixon's mitigation case at that time, which Mr. Dixon was asking the court to consider in allowing him additional time to develop that. And I'm sorry, did you have another
Was
question?
there resistance on Mr. Dixon's part to present certain mitigating evidence?
Well, and this is something that you will hear about from Mr. Mabry as well, but Mr. Dixon did not believe that he was mentally ill. You'll also hear from Dr. Toma that is the hallmark of schizophrenia, that people do not believe that they have a mental illness. So Mr. Dixon was open to presenting more mitigation than ultimately was presented to the jury, apart from mental health mitigation, but he simply did not have the time to prepare. As I noted in my opening remarks, he was also trying to develop this mitigation case from the county jail with all of the limitations that entailed. If I could just go back to a question that you had for Mr. Sandman earlier about Judge Klein's findings with respect to the legal disagreement between Mr. Dixon and his attorney. So I think it's just important to understand the claim that Judge Klein was reviewing. That was an ineffective assistance of counsel claim, which required the court to ask, was Mr. Simpson ineffective under the governing Supreme Court case Strickland versus Washington, which sets a really high bar for defendants to overcome in order to establish that their attorneys were ineffective. So the question before Judge Klein was not whether Mr. Dixon was mentally competent retrospectively at the time he elected to represent himself and fired Mr. Simpson. The question before Judge Klein was Mr. Simpson constitutionally ineffective under Strickland versus Washington for failing to alert the court to Mr. Dixon's inability to rationally communicate about his case before he waived counsel and was allowed to represent himself. So I just wanted to add that piece to our response. And then the second piece was that post-conviction counsel requested a hearing on Mr. Dixon's competency in the state post-conviction process and supported that request with the reports of Dr. Toma and of Dr. Amezcua-Patino, and the request for a hearing was denied. So until Judge Olson ordered a hearing on Mr. Dixon's mental competency, certainly in a different context to be executed, there has never been a court hearing on whether Mr. Dixon has been mentally competent at any point throughout this whole process.
My recollection from reading the records is that Judge Klein carefully considered that there's a difference between competency to represent yourself, competency to stand trial, and insistence that your position is correct.
Mm-hmm.
And we see that all the time from lawyers. I mean, and certainly the lawyers who filed legal documents arguing that the election was fraudulent were insistent that that position was correct.
Right.
And I don't think that they're incompetent. Their position might be wrong, but they were, however, insistent that that legally wrong position was correct.
Right.
And that's the finding that Judge Klein seemed to be making, that while he was insistent that this case that he kept citing fit the facts of the case where he was acutely accused, did not amount to being incompetent. It was just stubbornness, essentially. That he was insistent that it did fit when it's clear that it did not.
And you will hear from Dr. Toma about precisely the meaning and the implications of that kind of rigid perseveration and how that fits into and is symptomatic of Mr. Dixon's schizophrenic illness. But you are correct. Judge Klein did make those legal findings in the context of evaluating a very specific Sixth Amendment claim.
The competency proceedings that are ongoing in Pinal County, the courts have the ability to stay the execution if they make that finding, correct? And get a finding in your favor.
We would have to seek a stay of execution in the Arizona
Sure.
Supreme Court.
But the courts, the
Yes.
judicial branch has the power to do
Yes,
that.
that's
Okay. Any questions from my colleagues?
I just have
Counsel, Mr. Johnson?
I had one question, and my question was, regardless to what a person's mental stability could be, is there an inherent right that if they want to defend themselves, that they get to do that?
Yes, there is. There is the right, the constitutional right to self-representation.
So regardless to what his mental capacity could have been at that time, he still had the right to do that, if that's his choice.
Right, and that's why whether or not Mr. Dixon was mentally competent to waive, he also had a corresponding Sixth Amendment right to counsel. And so whether or not he was competent to waive that Sixth Amendment right in order to vindicate his right to represent himself required the court to, or should have prompted the court to hold a hearing on whether he was mentally competent to make that choice between which constitutional rights he was going to prioritize.
Thank you.
Any other questions?
Just a quick follow-up, and the court did not do that.
No, sir, the court did not do that.
Thank you.
Are there any other questions for counsel? Okay, and go ahead with the remainder of your presentation.
So we are going to move into the section of the presentation talking about the breakdowns in the trial process. So we're going to speak with Mr. Garrett Simpson. And this is going to be a sort of structured dialogue where I will put questions to Mr. Simpson and he will respond. So if you will bear with us. Can you please introduce yourself to
Yes,
the
good
board?
morning. My name is Garrett Simpson. I'm an attorney here in Phoenix, Arizona.
Can you tell us about your education, background, and your professional training, please?
Right. I've been a member in good standing State Bar of Arizona continuously since 1977. I grew up in Glendale. I went to Glendale High School, Northern Arizona University, went to the University of Tulsa, Oklahoma College of Law, where I got a JD degree in 1976. And I returned to Arizona, where I was determined to have a legal career.
Thank you. And can you talk about when and how you became involved in Clarence Dixon's case?
Right. After I got admitted to the bar, I was in private practice for a while, but then in 1985, I joined the Maricopa County Public Defender's Office, where I remained employed in a variety of capacities until 2014, when I retired. And and during that time, I was chiefly an appellate lawyer, but then in 2005, during the administration of Andrew Thomas, there was a wholesale transfer of lawyers to the capital section because so many capital cases were being alleged by the county attorney's office that they were very short-handed. And so I was asked to go to the capital trial unit, and I did in 2005, just about the time this case arose.
And when exactly were you appointed to Clarence's case?
I can't give you an exact date. It was in 2005 sometime, as I recall. I was made a second chair to another lawyer in the office, and then that lawyer left the office, and then I was in charge. And so I want the board to be clear that the error here in not requesting a competency determination on Mr. Dixon is my mistake. And it seems to me it's like the hinge the gate swings on. We wouldn't be here if I hadn't made that misjudgment. But I was superficially, it never occurred to me that he might not be competent because he was so adamant and so clear and articulate in what turned out to be his delusional beliefs.
Did you plan on raising an insanity defense when you were appointed to Mr. Dixon's case?
Yes, when I figured out that he had been found to be not guilty by reason of insanity, and was subject to a commitment proceeding order entered by Judge Sandra O'Connor, and that this was just a matter of 2 days before the homicide, before the terrible murder of Ms. Bowden. I knew that had to be the preferred course.
And talking about the 1977 NGRI proceedings, in that context, Judge O'Connor ordered that 2 mental health experts evaluate Clarence before she reached her insanity verdict. Are you familiar with either of the mental health experts who she appointed to evaluate Clarence, either from your time as her bailiff or as a capital defense attorney?
Yeah, right. I was Judge O'Connor's bailiff from most of 1977. I had been a producer and writer at an all-news radio station where she became a guest because at that time she was majority leader in the state Senate, as I recall. And she would come on and talk about Watergate because that was the big news of the day, and there were a lot of Arizonans who were involved in Watergate. And so I became acquainted with her when I got out of law school and was studying for the bar. I applied to be a bailiff, and she needed a bailiff, and she remembered me, thankfully, and it was one of the best experiences of my life. So I was her bailiff during the pre-trial portion of this case. I don't really remember any of those proceedings, but I do remember working with, or rather, talking to and getting to know Dr. Bentheim especially. Otto Bentheim was a very well-regarded psychiatrist back then, and he was a total pro, and I got to know him from simply being the bailiff and being around and reading his reports in a variety of cases. And it was just a wonderful experience to be Judge O'Connor's bailiff, and very grateful for having had that.
Do you recall what the results of Dr. Bentheim's and there was also Dr. Tukler's
Yeah, my
evaluations were of Clarence at that time?
I don't recall from the time, but later I became aware that both of them found that in that case, which was a bizarre attack, I believe on someone with a pipe, I could be wrong, he was found to be, their opinion was that he was insane, and that he was insane at the time of the assault. And previous to that, I learned that he had been found incompetent to stand trial under Rule 11. So as I recall the process, and this was very rare for Judge O'Connor or anyone to find someone actually insane. And what they would do is when they realized someone really was insane, they would tend to submit the matters to the court, and then the court would make a determination. And so I think what happened, I could be wrong, they decided that this was what the course was going to be. So the jury didn't find him not guilty by reason of insanity. I believe what happened is they waived jury trial, and it went to the judge, and the judge considered the reports and returned a verdict. And in order to do that, she had to find that he was competent to be tried, which was really, I would guess, a pro forma in order to get him out of the criminal justice system. And so they found him competent to be tried. Then they found him insane. And then she said, in the very next breath, that he was a danger to himself or others and had to be committed to the state hospital, and ordered the county attorney to begin those proceedings.
And those proceedings, as far as you're aware, never happened.
They were never done, and they were supposed to do it, as I recall, within a 10-day span, but it never happened. And so he just sort of drifted away, and that was another failure, compounding this matter. It would have never happened. This would have never happened. Ms. Bowden would still be with us if the county attorney's office had obeyed Judge O'Connor's order back in 1978.
And so fast forwarding to your representation of Clarence in around 2005 and 2006 in his capital case, can you talk about where the breakdown in communication happened, and just about what it was like for you to try to communicate with Clarence about his case?
It was deceptively easy to talk to him because he appeared to be functional. He was about so many things except his belief in his issues regarding the Northern Arizona University Police Department, and that fooled me into thinking he was competent when he wasn't. I should have, given his vehemence. Looking back, it's absolutely clear to me that I made a mistake. I made a huge error and I am responsible for that error alone. Because by the time the decision was made, I was lead counsel. And so it was up to me and I screwed up. I didn't do the right thing. I should have demanded a Rule 11 proceeding, but I did not. And I believe this was, and I cannot say whether this was right about the time he was firing me. And the office, I was a public defender, I wasn't a private lawyer. The office determined that I should permit him to go forward with that. And so I did, even though at that point we had evidence concerning his history of severe mental illness. But at that time, as I recall, the law didn't require someone to be vetted by a psychiatrist to be competent to take over their own case. I believe they've changed that since then, but I'm not totally sure of that. But at the time, it wasn't the case.
And at some point, you wrote Clarence a long memorandum explaining factually why his belief in the viability of this NAU claim was simply not borne out factually. Can you talk about that and just whether that was enough to sort of get through to Clarence?
It wasn't enough. And again, I was hoping it did not occur to me to react to it by asking for a Rule 11. That was my mistake. It should have, but it didn't. And I drove right through that red light. And I have no one to blame but myself for that. It was just the wrong call. It was just, it was just the wrong decision, and I made that one.
And had you remained as Clarence's counsel, what would your mitigation presentation on his behalf have looked like? Would you have put mental health evidence before the jury?
Well, like I say, Dr. Bentheim I'm not sure he was still active. This was 15 years ago and much after the crime, but I would have gotten the records and made the G1 mitigator, if you follow, the substantial impairment mitigator as the factor to consider and bring up his life history, the trauma he suffered at birth, and his poor development, and all the mental illness he was diagnosed with back in 1977 and 78. And more than anything else, it was crystal clear that Judge O'Connor, who was nobody's fool, please believe me, I was her bailiff for almost a year, and in a courthouse full of bright judges, she stood out. I mean, she always did and always has. But she was nobody's fool. And if she decided on day one that this person was a danger to themselves and others and was gravely disabled and needed to be committed to the state hospital, and 48 hours later this crime happened, there was a very valid insanity defense, and if nothing else, it was compelling evidence of mitigation. And so that would have been the centerpiece, of the whole mitigation presentation.
And you've handled a lot of capital cases throughout the course of your career. Do you believe that had you been able to present that evidence to Clarence's jury, that he would have been sentenced to death?
I believe he would not have, and I'm disappointed that his ultimate advisory council aren't here to repeat that refrain. I think it's really unfortunate and wrong. But yeah, in fact, I delivered my work to them. I walked it over to them. I was bicycle commuting at the time, and I actually walked over the manila envelope with my research and dropped it at their office, and never heard another word. And by then I had, and this was in the middle of the Andrew Thomas era, and I had a basket full of capital cases I was handling, and I had been relieved. But it was a mistake for me to let him go without having him properly seen by a psychiatrist, and that's my fault.
Thanks, Garrett. Are there any questions for Mr. Simpson?
I do have a question for Mr. Simpson. So after you were relieved, who was Mr. Dixon's counsel?
I believe there was a lawyer named Ken Countryman and another lawyer named Nathaniel Carr.
Okay, and we have affidavits from them.
I have not seen them.
Was any other lawyer who represented Mr.?
Well, initially, Vicki Lyles and Victoria Washington were the counsel on that case. But again, like I say, they didn't make that decision, that bad decision. I made it.
But his subsequent counsel, Mr. Countryman and Mr. Carr, never believed that a Rule 11 proceeding request was needed either.
I can't speak to that, but I don't know what they were thinking. They might have been fooled as I was he wasn't raving, he was just irrational, and I guess I mistook the irrationality for vehemence. You know, as you were saying, ma'am, you know, that can be the case, but he was deeply, deeply mentally ill, and that's why I was so happy to come here, because this is the backstop. You know, one of my great mentors was Larry Hammond. Maybe you remember Larry Hammond.
Very well.
Huge baseball fan, and he said this board was a backstop for the wild pitches. And so this isn't a legal appeal. This is just like they said, an appeal for mercy, because you're the backstop. You folks are the board that can actually stop this injustice. And you wouldn't be here on this case if I didn't make that mistake, number one. And if the county attorney hadn't made the mistake of not following Judge O'Connor's orders, Ms. Bowden would be here too, I bet you. And that's just the way life works out sometimes.
And-
Any other questions of Mr. Quinones?
Thank you. Thank you, Honorable Ms. Mendez. Just a question really for all the legal counsels. I don't know if you can answer this, but wasn't Mr. Dixon found fit to stand for trial by the Arizona State Hospital before the aggravated assault case leading up to the decision that he was not guilty by reasons of insanity?
That's right, yes. So he was found mentally, the bizarre assault that ultimately led to Judge O'Connor's insanity verdict happened in June of 1977 or thereabouts. He was subsequently found by court-appointed evaluators to be mentally incompetent, was committed to the Arizona State Hospital for several weeks where he was prescribed antipsychotic medication. He was found restored to mental competency for purposes of standing trial on that charge. And that is when Judge O'Connor found him NGRI in January of 1978. So he was mentally competent to stand trial in January of 1978. But what's significant is Judge O'Connor's subsequent civil commitment order, because she found, notwithstanding that he had recovered mental competency, he was still so ill and presented a danger that she ordered the county attorney to get him committed to the state hospital.
Also, there seems to be a gap in this story, and that is, I think, the language that was used, that he drifted away, but I'm not quite sure how that happened. Meaning, wouldn't he have been remanded to the Maricopa County Sheriff's Office or to detention? I don't understand that part of the process.
Right, and neither do we. It appears that after the NGRI finding and Judge O'Connor's order that the county attorney's office institute commitment proceedings, that he was just released and that there was no supervision, there was no follow-up. At the time, he was still enrolled at Arizona State University, and he did not disenroll from Arizona State University until January 12th of 1978, so the following week. So there is a gap there, but he was not under any sort of supervision.
I am not here to defend the Maricopa County Attorney's Office, but why is that their fault?
And it's not about allocating fault. I think what we're talking about is the institutional breakdowns that are part of the context for how we got here, right? And there is responsibility, institutional responsibility, that the Maricopa County Attorney's Office, as a prosecuting entity, as an entity that is charged with safeguarding the public, in the face of an order like that from Judge O'Connor, finding this person a danger to himself and others, and ordering him, to begin the process of getting committed to the state hospital. It's unfortunate that was not immediately acted upon, or that he was not kept under some sort of supervision until those commitment proceedings could play out. And so I think when we talk about the Maricopa County Attorney's Office, it's also in the context of this overall picture of how, public safety, Clarence, being just released on his own into the community, notwithstanding Judge O'Connor's findings, represents a breakdown in the process.
Thank you, ma'am.
Mr. Johnson?
Thank you. Mr. Simpson, just kind of in my mind going through some of the things you just said. So you were actually appointed in 2005 to represent Dixon?
I was assigned to the case. The Maricopa County Public Defender's Office was the appointed attorney,
Okay,
but I was their deputy.
okay, so you were assigned to the case
Yes, sir.
in 2005, and then when did you become the lead counsel on it?
I don't have the date fixed in my mind, but what happened was that I was the second chair, and then Ms. Lyles left the office, so I took over as first chair. And I can't give you a date. I apologize.
Okay, could you estimate how much time between the second chair and you took over?
I could not. It's been a long time.
Okay. So during the time that you were assigned the Dixon case, did you have times where you appeared in court and you sat right next to him, or did you have times when maybe perhaps you were at the jail, you had interviews with him as
Yes.
his representative? So how many times would you say you did that?
I cannot give you an estimate, but I remember speaking with him at the Madison jail,
Uh-huh.
and I spoke to him in court, and we had discussions about this very thing, about his unfounded belief in the illegitimacy of the Northern Arizona University Police and why that was important in this case. And, but other than that, he gave the superficial appearance of being rational. But it was that very thing that should have been the key to me to have him seen by an expert. I don't have any mental health training. I'm a lawyer, and I should have thought I wasn't the smartest person in the room, and I should have signaled for help, mental health assistance in evaluating him, and I didn't do it.
So when did you make that determination? I mean, how long after those hearings did you make that determination, and what brought you to the conclusion to make that determination?
Which determination, sir?
The determination that you were wrong, you made a wrong decision, you made a
well.
mistake.
Right. Well, it would have been after I was relieved and I realized that his incompetency should be asserted, and insanity in terms of the time of the crime and mitigation is when I took the packet of materials over to Carr's office, Nathaniel Carr's office, or Ken Countryman's office. I mailed it to one and walked it over to the other. And so I can't give you the exact date, but I believe I did an affidavit in the post-conviction proceeding where I talked about when I did that. But it was after I'd been relieved, and I gave them the materials and asked them to please file it.
Okay, so during the period of time that you actually were the second, and then the time that you were actually the lead counsel representing him, you never got the feeling that there was some mental capacity that was just there. You just believed that, as you were saying, I believe you said that he was very confident and adamant about his decision and what he thought.
Yeah, he seemed to be, but again, that was a mistake on my part and not his.
Okay, so have you had other hearings where the defendant wanted to represent themselves?
Yes, I have.
Okay, and so when you've had those hearings, were there some times when the person you were represented had their own ideas about what they wanted as opposed to what legally would be the best interest of them?
It would be hard to characterize that. I'm not sure I understand what you're getting at, sir.
Well, you said that during the time that you represented Mr. Simpson, at the time that you represented Mr. Dixon, that he was very adamant about what he thought and what he believed.
Right.
And I'm asking you, when you had other clients who may have represented themselves, were they very adamant as what they believed and thought as opposed to what you may have thought was the right thing to do?
Oh, yes, of course, absolutely. And that would usually get resolved. This was the only case I can think of where it was resolved by me being discharged.
Okay.
So it didn't strike me as extraordinary until he made the move to have me fired.
So is that an unusual thing for a defendant when they decide to represent themselves and they feel as though the appointed representation they have is not representing their best interest?
It's the kind of thing that happens a lot in court, but it didn't often happen to me at all. This was the only time in a case of this seriousness that anything like that had ever happened.
All right, thank you, sir. Thank you, Ms. Mendes.
Just to follow up on that, Mr. Simpson.
Yes.
This hyper focus, so to speak, that he had on this issue relating to the NAU police and the case law that he was trying to fit the facts of his case into that case law. Was that the only issue that he was adamant about or insistent about or hyper-focused on, or were there other issues that he had that same degree of what you termed as irrationality?
Well, to me, that was the only thing he cared about, because it was the it was the thing on which everything else would turn. But and so nothing else really mattered to him. And again, I should have picked up on that as a delusion or whatever you want to call it. I'm not a medically trained person, but it should have been a warning light for me, especially because as we were acquiring this evidence of his mental health history, and I should have been more aware of it, and I was not. I didn't act on it. If I knew it, I didn't give it effect, which I should have done.
Okay. All right, any additional questions of Mr. King?
Just a quick follow-up, Mr. Simpson. Had you dealt with clients with schizophrenia in the past?
Yes, in fact, almost simultaneously, we had a case that I was lead counsel on where the client was schizophrenic and actually had shot and killed 2 people, and we were very much involved with it, and almost at about the same time. But he never asked to have me cashiered. We worked the case, and actually we were able to get it dismissed.
I know this is a hard question, and I think we'll probably get into this later about how people with schizophrenia, and I can't speak for all cases, but can appear very rational and then leave reality. But were you getting the impression that he was schizophrenic when you were dealing with him? That has been my experience, by the way. I have spoken to people with schizophrenia, and everything seems kind of fine, and then there's that sort of departure from reality moment. Were you getting those departures from reality?
Particularly about the NAU Police Department, yes. It's been a long time, so please forgive me, but he did seem to be otherwise superficially rational, but I was mistaken. And when I became convinced of that, I took the materials to Cara and Countryman and hoped that they would act on it, but they did not either.
Thank you for your answer.
Can I just ask one more question, just
Yes, go
real
ahead.
quick? So, sir, you just told Mr. Quinones basically that you had other cases like that, but this was the only case that the client or the defendant actually cashiered you, or basically that's your word terminology that you use, cashiered you.
Finally,
Yeah, from the case, which basically means remove the case. But were you offended that he removed you from the case?
No, it was just, no, it was professional. It wasn't personal. I wasn't offended. And in all honesty, we had plenty to do during the Andrew Thomas era. And you can only hope that, the right decisions were made. And again, like I say, I'm at the intersection of all the things that went wrong here. All the things that went wrong were the product of my era and the county attorney's era before me in 1978.
So it was actually after you got cashiered or removed as the attorney that all this change of opinion that you came to light that actually you made a mistake because there were some things that were done.
Yeah, and that was in the process of moving the files over to them, and there wasn't, like I said, I did take the motion to dismiss over to them or to raise the mental health questions, but they did nothing with it, and they never tried to, as far as I know.
All right, thank you, sir.
Yes, Mr. Frank.
Yes, Mr. Simpson, you wrote Judge O'Connor a letter, I saw it, where you said you were the bailiff. Did she ever respond?
Yes, she did. Yeah, she did respond, and she's a very gracious person. She did respond and said that she had no recollection of the matter at all, which is to be, understood when you have busy court calendar and so on, and asking her 20 years later, what did you do on this? What did you have for breakfast? She had no recollection, and I didn't expect it, but she was the one person I really felt I needed to reach out to.
I just didn't see a response, so I was wanting to know what happened.
The response was she had no recollection of the matter, which is sad because I would have loved to have gone and interviewed her.
Thank you.
All right, if there are no further questions, Ms. Bass, you can proceed. And
Thank
where are you at in terms of your presentation? I'm trying to
Yeah.
figure out if this is a good time to take our morning break.
If we, I think this would be a fine time to take a morning break. If I could just respond to a question you had just a few moments ago.
Sure, why don't you do that?
Okay,
we'll
and then
break.
we can take a break. Okay. So you had asked about the advisory lawyers who were assigned to represent Clarence after he waived. And so I just want to clarify that those lawyers were not, and you will hear this from Mr. Ty Mabry, who will be testifying next, were not actively involved in Mr. Dixon's case at all. Whether they received or saw indicia of Clarence's mental illness is actually borne out through their billing records, which I believe are exhibits that we submitted in federal court in support of Mr. Dixon's petition for federal habeas relief, but which the federal court could not consider because that evidence hadn't been first presented to the state courts. And in those billing records, you'll see Mr. Carr and Mr. Countryman saying things like, defendant crazy, or, obsessing over this issue again, or, court was a disaster today, or how are we going to get this train wreck, salvaged? So you do not have those materials in front of you, but I believe those are exhibits to the federal habeas petition and the motion for expansion of the record that we filed, which show that they saw that something was off.
All right, thank you, Ms. Bass. So the board is going to take a 10-minute recess at this time. Right now it is 10:21. I would ask that everyone be back and ready to proceed at 10:31. All right, thank you, everyone.
I'm not sure that's necessary.
And then just tell me what you're requesting.
Oh, yeah, that's fine. I don't have access to get to that.
I remember the last one.
All right, yeah, you have your right. Okay, that's fine.
Yeah, right, exactly. No, I know. Right, all right. Like even during the food meetings, I get emails.
Still trying to track her down.
No, Susan was over at her office.
You speak?
All right. It's 10:32. And Annalisa, we're back on the record?
Yes, sir.
All right, thank you. All right, the time is 10:32. This is the Arizona Board of Executive Clemency. And at this time, following our morning break, we will be resuming the hearing to consider a recommendation for commutation of sentence of reprieve to the governor for Mr. Clarence Dixon, ABC number 038977. And Ms. Bass, you may proceed.
Thank you. Mr. Mayberry, can you please state your full name? And you'll just need to turn on your mic right there. You'll just, yep, there you go.
My name is Tyrone Mayberry.
And can you tell us about your education, background, and training?
Sure, I have a bachelor's degree from Arizona State in Justice Studies, and I spent probably about 4 or 5 years doing casework as a caseworker for ComCare and for CPS. And then I started doing mitigation in about 1998. I trained with Mary Duran for a couple of years and worked with her. And then I started doing mitigation on my own probably around 2000. And I was doing it privately through the Office of Contract Counsel. And then the last 8 years of work, I've been working with the Office of the Legal Advocate as a capital mitigation specialist.
Thank you. And when you talk about mitigation, can you explain what you are referring to?
Mitigation is basically you gather information and tell the story of a person's life and how it relates to maybe the offense and how you get to the situation where whatever happened, and you explain it and try to get them the best sentence you can possibly get them.
And can you tell us how you came to be involved in Clarence Dixon's case?
I was appointed by the Office of Contract Counsel, and I'm not sure if um, Mr. Countryman or Mr. Carr requested me, or if it was just my turn on the list of getting cases, but I was appointed by Contract Counsel.
Do you recall when you were appointed?
It was in July of 2006.
And what were you appointed to do?
Do the mitigation for Mr. Clarence Dixon.
And at the time you were appointed, he was representing himself. Is that correct?
I believe so.
Okay.
I believe so. When I got the case, I was working with Mr. Simpson's second chair, Vicki Lyles, and she had a conversation with me about what needed to happen with the case. She said, this is going to be, pretty quick. All you have to do is file a motion to say he's not, he's insane and not competent, and this will be a piece of cake. You guys won't even be around. So I was like, all right, this is a pretty easy case to take. So.
And so you were brought on to Clarence's case to help with the mitigation workup. Can you describe just generally in your capital case work, what a mitigation investigation entails? I know you talked about generally sort of what you try to present, but just in terms of how exhaustive it is and how much, whether it's record review or witness outreach and travel, can you say a little bit just about how much work is involved?
Sure. A normal capital mitigation case usually takes a couple of years to get everything you need. You have to request every document that's ever been out on a person, school records, medical records, any type of therapy. You have to go out and meet with all their family members, friends, counselors. Sometimes you have to go investigate what happened in the scene and see how it relates to your client. You also have to spend, sometimes thousands of hours with the client themselves, doing interviews, with their family. You do interviews with them, gathering any type of information on the family and the social history. You put together a full chronological history for the client, and then you hopefully get them prepared for trial at that point.
And do you also help identify experts or find experts as well?
Yes. Yeah, that's actually a big part. Once you've interviewed the client and the family and spent time with them, and you have some information which direction you're kind of going, at that point you will tell the attorneys kind of, this is the direction or the experts that I kind of see we're going to need in this kind of a case.
Did you have the time or the ability to do all of those things in Clarence's case?
No. The case from the very beginning was kind of a mess. I didn't get any records for, I don't believe, 3 months. And then when we did get the records from the attorneys, it was just in several boxes, just everything unorganized, and kind of just everywhere. None of it made sense. So I had to hire another mitigation person just to kind of organize the files for me, put everything together. I know Mr. Simpson said that at that time we all had a lot of cases. I think I had 9 cases going on at the time, which is completely insane to do. You should have about 3 cases as a capital mitigation specialist at most. I had 9 at the time, so most of what I was doing at this point was putting out fires, and that's about all I could do. It was difficult to do much more on these cases.
During the time that you worked on Clarence's case, did you see any indicia of mental illness?
I did. When I met with him, he was fixated on his other cases. He appeared delusional. His beliefs appeared delusional. No matter what we talked about, it always came back to discussing the other cases and how he thought they would work out. And we really couldn't talk about a whole lot of other things because he was so fixated on the other cases. I also saw some paranoia. He reported to me hearing voices in the jail. you know, there were some minor signs of psychosis, and I can't tell you what they were today, but I believe that I remember him discussing signs of having psychotic behaviors and stuff.
And you mentioned Clarence's obsession with the other cases. Those are the 1985 NAU police jurisdiction cases, or were there other cases besides that he was obsessed with?
Sorry, it was the case in Flagstaff, and I'm not
Okay.
sure which year it was and what happened, but it was the case in Flagstaff. His belief was if they found him guilty, if they gave him the death penalty and they found him guilty, that case would be overturned as well. And so he was just so focused on that, even though I told him that's not how it worked, and I explained kind of the process and how this would work out in trial. He didn't understand it and was just not capable of picking that up.
And so just to make sure I'm understanding what you're saying, so Clarence believed that if he were found guilty in the capital case, that was going to allow him to challenge the cases that he really cared about?
Correct.
Okay. You talked about him not being able to understand what you were sharing with him about the reality of how the legal process worked. Were there other ways in which you were unable to or had difficulty communicating with him in a sort of rational, fact-based way?
No matter, he couldn't retain information, no matter how many times we went over it or tried to explain it. There really was no rational way to have a conversation and him be able to carry out and understand what we were talking about. When I spent the last couple months before trial just explaining to him how witnesses, how you have to question witnesses and things about the process of the trial, and he just could not understand that at all.
Do you believe that Clarence was mentally competent to represent himself in his capital case?
I don't. He was not able to help his defense counsel at all. There was almost no help he could have provided to his counsel during the trial.
Can you talk about Clarence's advisory council and what their role in all of this was or wasn't, and what you saw them, doing or not doing throughout this process?
Because they were advisory council, they informed Mr. Dixon and also myself, because I had never had this situation happen before. They had told him that they could only answer his questions. They really couldn't do anything else, that he had to come to them and tell them, ask a question and then they could respond to that, but they couldn't do anything else. So what I witnessed was, it was hard to watch because I knew they knew the answers and I knew they could help him, but they couldn't do it. So it was a difficult process to watch. They basically sat through the trial, texting each other, doing nothing to help Mr. Dixon prepare, to understand what was going on, to help him write questions or even understand any type of strategy involved in questioning the witnesses.
Did Clarence's advisory lawyers or you alert the court to, just these problems and more specifically the issue around his fixation over his other cases and some of the difficulties that you were having rationally communicating with him?
I believe we did. I wrote a letter to Mr. Dixon indicating, look, we can't go to trial with your mitigation the way it is. At the point the judge said we were ready to start trial, I had not interviewed any witnesses. I hadn't had a time to review the document, all the records, and it was basically we scratched the surface in mitigation. Just a few interviews with Mr. Dixon that was nowhere near enough to say you were prepared for trial.
Okay. Did you attend the entire trial?
I did. I think I attended every day.
Can you describe what it was like to sit through that trial?
It was a nightmare. It was borderline traumatic. It was like watching someone you knew was struggling and just, it was almost inhumane that we could not help him in any way. I wasn't allowed to give any type of legal advice. I wasn't allowed to do anything except for help him have the records he was, he needed for the day. And to just be there to try to talk to him and try to encourage him to get through it. At some points he gave up. I could tell the prosecutor was objecting to almost every question he asked, the way it was formatted. And I could tell Mr. Dixon was frustrated and just had given up, and it was tough to watch. It was difficult to watch. It actually prepared me for the rest of my cases that I've done since. I will never let my clients go pro per. I do everything I can to possibly talk them out of going pro per now.
In sitting through the trial, did the jury know about or get information about Clarence's longstanding history of mental illness?
No.
Did they know about the prior insanity findings 2 days before the crime occurred?
No.
Okay. Was there any information that was presented about his schizophrenia diagnosis going back to the 1970s?
I don't think there was.
And was there any information about his childhood upbringing? You talked about, the life history part, abuse, neglect. Was any of that sort of information given to the jury?
I don't believe there, I know Mr. Dixon called an expert on future dangerousness, but I don't believe he discussed anything. So I don't think that there was anything discussed.
Okay. So you had a communication with a juror after the trial, is that correct?
That's correct.
Can you talk about that and tell the board about that dialogue?
Sure. One of the jurors in the case was a sister of another capital mitigation specialist that worked in another office. And I knew the name. And so after the trial, I saw her walking out, and I could see she was, she was still a little stressed and upset about what had happened. And so I went to just introduce myself to her and say, hey, I know your sister, and just be nice and just have a quick conversation. Another juror had walked up to me and said that, they were curious. They wanted to know, was there more that they weren't allowed to hear? Was there any type of mental health stuff going on with Mr. Dixon? And honestly, at that time, I could have went on for hours about the mental health stuff. So I just said, you just didn't hear everything. You weren't allowed to hear everything that could have been presented. And that was kind of where we left it at that.
Do you, in light of the communication you had with someone who'd served on this jury and in light of your experience in capital mitigation work in the decades since, do you think that had you been able to, or had an attorney who was representing Clarence been able to put all of the information that you could have gone on for hours about with this juror outside of the courtroom before the jury, that Clarence would have gotten a death sentence?
I am, as confident. This case had as much mitigation probably as any case I've ever had. First of all, I don't think it ever should have gotten to a trial. I think we could have stopped it well before had he let his attorneys, file the right motions. But secondly, once we got there, I think all the mitigation that we had definitely would have given a jury enough to give him a life sentence.
And can you also talk about, you mentioned earlier that, in all of your cases since working on Clarence's case, you will never let your clients go pro per, at least without, not without fighting that. Are there differences in the kinds of procedural protections that you have seen over the course of your career, but, when it comes to allowing defendants to represent themselves in capital cases, perhaps even protections that weren't in place when all of this was happening with Clarence, but that you see courts more vigilant about now?
Absolutely. I have a client right now who just back in November decided she wanted to go pro per for her reasons, and she actually has no mental health issues and no reasons to question her competency. But the judge ordered her to be in Rule 11 and to test her competency to represent herself before she can allow her to go pro per. That wasn't in place back then. It's a completely different level of. I mean, it's been almost 4 months, and we're still trying to find if this lady's competent, and she's completely competent. There's no questions about this. But back there, that wasn't the case, and even mitigation specialists now. I'm sure we discussed Rule 11 between Mr. Carr and Mr. Countryman, myself. But I can tell you right now, with my experience of today, I would have been insisting and screaming to put Mr. Dixon in Rule 11 from the very beginning. My first interviews, I would have said he needs to be in Rule 11. It was earlier in my career. I don't have the knowledge that I have now and experience, but that was a mistake I made as well.
I'm sorry, when you talk about Rule 11, what are you referring to?
It's to see if he's competent to stand trial, to test their competency. It's mental health evaluations, basically, where they test to see if you're mentally stable, competent.
Thank you.
Further questions?
Yes.
Is Mr. Mayberry correct?
Yes.
Am I pronouncing it correctly?
Yes, you are.
Okay. All right. So Judge Klein, who's a very respected jurist, he would have had the power on his own motion to order a Rule 11 evaluation if he believed that there were issues with the competency of Mr. Dixon, correct?
I believe so.
Okay, and he did not elect to do that.
He did not. At least not that I know of.
And you kind of described in your statement the trial as being, I think the word you used was a disaster. We've read a substantial portion of the trial transcript. So while there were times when Judge Klein redirected Mr. Dixon, instructed him to ask a question in a different way so that it would comply with the rules of evidence and rules of procedure, or instructed him on the meaning of legal concepts. I don't recall seeing an instance where Judge Klein stopped the proceedings or expressed any concerns about the trial being a disaster. Do you recall any instances of that nature?
I don't recall anything like that. I just, and again, maybe it's the way I was interpreting it. Every question that Mr. Dixon asked, it felt like the state objected to it. And so he would start and try asking it a different way. And again, it would fail. And so finally he would just be like, I'm not gonna ask the question. That's what I remember from it. And maybe it was just, that's the stuff that stood out to me and still stuck in my head. It just seemed really bad to watch. Him go nowhere. It was just floundering, trying to ask questions and couldn't get it out. So.
All right, any other questions from any of my fellow board members? Mr. Quinones?
Thank you, ma'am. Mr. Mayberry, is it a given that a psychologist would have found Mr. Dixon mentally incompetent, therefore restricted from representing himself?
Is it a given they would have found him competent?
What I'm saying is, when I listen to legal counsel, it sounds like it's a given, and I'm not sure if it was. He was found competent to stand trial by the Arizona State Hospital before he was found not guilty by reasons of insanity. There's been more than one psychological evaluation. So I'm just saying, is it the position of legal counsel that it's a given that a psychologist would have found him mentally incompetent?
I don't think it's a given. I think he would have been able to understand, who the players were in the courtroom. He would have understand kind of the process and the basics of what was going on. but he was not able to help his counsel now. Are there experts that would say, yeah, he probably could help his counsel? Maybe. What I experienced was he was not able to. So I can tell you what I got from it is he was not capable of cooperating or working with his counsel and helping them defend themselves. So, but I'm sure there's experts out there that might have found him competent.
Thank you, sir.
Mr. Freeman?
Mr. Mayberry, as a mitigation capital specialist, what your role is to provide information to the defendant or to the court?
It's to provide it to the attorneys and defense counsel, which he's representing himself, so it actually would have been him at that point.
And he would have to present it then to the court?
Correct.
How long did it take you to gather the information?
And this is a weird case. There had been someone before me appointed who had gathered all this records and documents. So by the time I got all those records and got them organized, we had started trial. We had already started trial. So I really didn't have time to say, okay, this is what this means and assess it and do any of that stuff. We were just trying to say, what can Mr. Dixon present? What is he capable of presenting to this jury? And we tried to make it as bare bone. I mean, actually, it was just me. It was make it as bare bone as he could possibly make it. He said he thought he could get through the expert that was going to do the future dangerousness, the warden. He started fixating on that. He really wanted to have that expert talk. And so we tried to at least get him ready to do that expert. And that went really long. He spent the whole time, I think, talking about his CV. And I mean, it was just it had nothing to do with Mr. Dixon.
So sorry.
No.
So in the sentencing portion, which took 4 years, it's a mitigation sentence. And I think Ms. Bass talked about it earlier. Are you present during that? Was that the information that you gathered?
I don't know what you're talking about. Sentence.
Ms. Bass, you
Sentencing?
said it was a sentencing mitigation. We have the file where it took 4 years to gather information before.
So, right, because Mr. Dixon waived counsel in around 2006, and his trial, before then, he had counsel from 2001 or 2002 until 2006, so for a 4-year period. And then when he waived, there was another, year and a half, 2 years that he represented himself, I believe, with Mr. Mayberry's work on the case before it went to trial. So there was, a 4 to 6 year window between his indictment and when the case went to trial. That is the period during which mitigation is developed so that it can be presented to the jury at the trial.
So that was 4 years to gather that mitigation evidence.
Right. And so Clarence's lawyers were gathering that for him before he fired them. And then there was a turnover in the representation because Clarence was representing himself. So then all of the prior boxes and all of the records from the mitigation specialist who had worked with Mr. Dixon's lawyers previously went to Mr. Mayberry. So he is a new mitigation specialist coming onto the case 4 years in. And I think, and I don't want to put words in your mouth, but I think that is the record that Mr. Mayberry was trying to get organized to help then Mr. Dixon carry his mitigation case forward. But it was essentially starting from scratch.
And then Mr. Dixon never provided that mitigation to the court. That's what you're saying.
No, he never did.
And then, Ms. Bass, you had stated that, and correct me if I'm wrong, that he wanted to be found guilty on the capital case, so then he could go focus on the NAU sexual assault case?
That was my understanding. Is he believed in his mind that if he got the death penalty, that all of his other prior cases would be reviewed and would get an appeal, just like the death penalty gets an ongoing appeal. He thought all of his cases, and he wanted those other cases to be appealed with the death penalty case. And I explained that's not how it works. It's over and over and over.
Yeah, the way I understood it was that he felt that the evidence was taken, unconstitutionally, and it would have been fruit of the poisonous tree, and then such that he wouldn't be found guilty, is the way I understood when I read it. But I just wanted to clarify if that was the case.
And I think that's what that's what he wanted. But I explained to him one has nothing to do with the second part.
Right. Thank you.
All right, any other questions? Mr. Johnson?
Just one. You said you represented other cases where the defendant represented themselves. Is it unusual when someone represents themselves that when they're in court and trial, that many of the questions and the way they ask to be questions, that there's an objection to it? Because there's a lot of difference between just going to trial and asking a question and legally being able to ask a question that would not be objectable, regardless to their mental state.
Yeah, I would imagine it would be difficult for anybody who's not an attorney to ask questions correctly, but eventually he would figure it out. Mr. Dixon never was able to figure that out. This was the only case that I had that actually went to trial. The case I have that I currently have that the client is asking to go pro per, I'm sure she's not going to go pro per. She wants to get new counsel appointed. And if that's going to get denied, I'm sure she'll be back and saying, let them represent me. But I've never seen a case where the defendant actually went to trial and tried to represent himself. Any client I have, I would do everything I possibly could to talk them out.
Thank you.
Mr. Kenyon?
Thank you, Ms. Mendez. Just a follow-up question. When a defendant is found guilty but insane, I think that's a possibility. What are the sentencing options? I guess I'm
Karen,
asking in
do you know
general.
if you can speak to that?
You'll never be released. I mean, you're either going to be hospitalized, and if you no longer need hospitalization, then you'll spend your time in prison. So
Okay.
back in the day when Judge O'Connor found Mr. Dixon insane, then you were not guilty. But now we have guilty but insane. So it really allows at least some opportunity for treatment, but
So
not
they
like if you
could
get
go
better,
to the
you're not
state
gonna get out.
hospital, or they could go to prison on SMI status. I mean, there's a variety of things that
Yes,
can happen. I
yes.
just don't know. I didn't research that.
I
Thank
think
you.
it would vary on the case as to how much time in the hospital, how much time SMI in prison. But you're probably right. Probably most of the time it'd be SMI in prison, but they don't get out.
Thank you.
All right, any other questions?
Um,
Okay, there are no other questions, go ahead.
If I could just also respond in part to your, Ms. Mendez's question about Mr. Dixon's apparent ability to represent himself during the trial. So I think it is also important to look at the record on appeal in this case and to see that, so immediately after Mr. Dixon waived counsel, he filed a motion to suppress the DNA evidence based on this NAU issue. Judge Klein denied it. Mr. Dixon filed, I believe, a motion for reconsideration of that denial. When that was denied, he special actioned it to the Arizona Supreme Court. That was denied. He sought to then recuse Judge Klein for bias in denying his claim. He filed 3 or 4 motions to recuse that were all denied. And so there were places in the record where you see Judge Klein trying to explain to Clarence, you can take this up with the Court of Appeals. This is a motion that's already been decided. And there are places where he also, Judge Klein, asks Mr. Martinez, the prosecutor, to interpret what Clarence was saying because he simply couldn't understand what Clarence was trying to convey. And so I think those are places, both in the transcripts and in the record on appeal, where you see that this is not just, someone who is a layperson who is having difficulty formulating questions for direct or cross-examination. This is someone who is obsessive and unable to really appreciate what is happening throughout this process. And so I think there are places where you see Judge Klein grappling with that a bit. Mr. Frenny, to your question about the mitigation that Clarence had, again, I don't want to put words in Mr. Mabry's mouth, but I think it's important to know that there was a lot of material to work with. But by the time the court at some point said, this case has been pending since 2001, yes, you represented yourself, you started representing yourself in 2006, we've got to try this case. So I'm not giving you any more continuances. At that point, Clarence's mitigation case was a disaster. And I think maybe, Mr. Mabry, you can speak to that a little bit, just how there was a lot of information, but wasn't ready to be presented in any sort of way. Were there experts who had been retained? I mean, can you say a little bit about that?
Sure. Again, when I do a normal capital mitigation and have it ready for trial, I've interviewed the witnesses. I know what they're going to say. I'm able to verify the defendant's story or whatever he tells me. I go through and I check everything and make sure it's all accurate, and I'm not just coming up with what the defendant is saying. None of that I was able to do any of that. By the time I got the records and had them organized, we were starting trial, and I didn't have time to spend going through everything and saying, okay, this is what his school records mean. Is there some sort of thing showing there's abuse at this point in his life? I wasn't able to do that. Normally on any case I have, you're able to kind of pick it apart and say, okay, this is where abuse is happening. This is where, maybe he's starting to show signs of schizophrenia or something's going on here. Normally you're able to go through the files and do all that. I wasn't allowed to do any of that because we started trial and we were just trying to put something out, just to have something that he could present to a jury. And ultimately, the only thing he chose to present was the warden, because he was so focused on what the warden was saying. And it really wasn't useful to his mitigation. But the file itself was just incomplete. It was a mess. There were no interview notes from the other mitigation specialists. I think my notes said that there were 2 people who had actual notes. There should have been everybody interviewed. I should have had all their notes. So when I got it, I wasn't able to go say, okay, this person said this. I basically had no interviews and no notes. So the only person I could rely on was Mr. Dixon. And you can't do that in court because that'll get your prosecutor will tear you up if you just say, okay, Mr. Dixon said this. So it was a mess. The files were a mess. And I don't know where that happened. I don't know if it was the first attorneys handing it over. I don't know where the mess happened, but they were so unorganized. And when I got them, it took me almost 6 months to fix. And with another person. So it was pretty bad.
How long were you the mitigation representative before it went to trial?
I got appointed in July, and I think it went to trial in November of the next year. So, but again, there was 3 or 4 months where we had no records at all, and there were several months where I couldn't do a whole lot because we were trying to focus on getting this thing ready for trial. So.
All right, thank you, Ms. Massey. Your next speaker.
Our next speaker will be Dr. Toma, who
Okay,
is virtual.
all right. So, let me just see here. Dr. Toma?
Yes,
if you
good morning.
press *6 to unmute your phone.
I'm using my microphone on my laptop. Can you hear me?
We can hear you, but not very loudly. Could you turn the volume up?
I can. Is this better? Can you hear me now?
Instructed to use the phone for audio.
Yeah, I said
Did he not do that?
he hasn't been able to get his laptop because his connection is fast.
All right, well, Dr. Toma, we sent you very clear instructions about how to appear so that you can be heard. So I'm going to ask everyone in the audience to remain as silent as you can. And Dr. Toma, I'm going to ask you to speak as loudly as you can because you didn't follow those audio instructions, so you are coming across very faintly. So let's see if this will work.
Is there a way to reinitiate the process? Or Dr. Toma, can you test it for us, please?
Can you hear me now?
Barely. Is it possible for him to sort of log out and then log back in according to Sean?
Well,
Oh, okay. Dr. Toma, if you can send your phone number. Oh, okay. They're going to call you so that you can have your video on, but then mute yourself, and then we'll hear you through your phone.
Okay, so I
While
just
staff
want,
is getting that
I want to let people know that I only have a cell phone. And that's why I didn't call in.
Okay, right.
Council and Dr. Thomas, while staff is getting his audio set up so that we can all hear it, the board is just going to take a 5 to 10 minute
Okay.
break.
Thank you.
Just the board though.
Okay.
I mean, clearly if someone needs to run to the restroom, go ahead, but I don't want everyone leaving the.
And I'll get back to you as soon as I
We will
can.
get back to you.
Thanks a lot.
Okay, can you try and call again? I didn't have my phone on.
It's from a Boston number.
I'm sorry, okay. If you called again, I didn't have my phone on when you called.
Okay.
Yeah, we're calling right now. It'll be a 617 number, okay? Can you mute, you want to mute your computer incoming and outcoming, so mute your mic and your speakers, and then the feedback will go away, okay? There you go. Can you talk into the phone so we can hear you?
I can talk into the phone.
Yeah, you gotta mute the speakers and turn the sound off on your computer.
Mute the speakers on my,
You don't want to hear me through the computer at all, so just like mute your computer. Oh, I'll do it.
there. Is that better? Can you hear me now?
Yes, that's good.
Hello?
Yes, yeah.
His computer's not muted, but like that, he's not muted.
We can hear you.
Yeah, he's muted.
And I would just try to speak up, okay? So the board's taking a quick
Okay,
break.
I
We'll be
can
back in
barely
about-
hear you.
What's that?
I can barely hear you.
Can you hear me now?
A little better.
Amanda, do you want to try talking into that?
Hi, Dr. Toma. Can you hear me?
A little bit, yeah.
Okay. I wonder,
Can you hear me?
Is there a way to just conference call? Just, yeah, that may, Dr. Toma, we're going to try to just, oh, he's out there.
Can you write down
Pardon?
his phone number and bring it to me? Okay, Dr. Toma, I'm gonna have you hang up the cell phone and I'm gonna call you from the speakerphone in the board office. So this will be a 602 number, okay? Or it might say unknown. I'm not sure if it's a correct number. Okay, so can you hang up? Hi, Dr. Toma, can you hear us? Is this better? Can you speak again? We're getting kind of a weird signal on our end. Dr. Toma, can you say something? I just want to make sure we're hearing you okay.
Needs to hang up on this.
Just kick him out.
If you turn this phone on to your phone, that might help.
Dr. Toma, are you there?
You need to call in again now. I can also.
Okay.
Worst case scenario, I'll just
This
call
should
in.
be, this should work, I'm sorry.
That's okay, I can also, if in worst case scenario, call them from my cell phone and just put them on speaker.
Okay.
That won't work because it won't record. It has to connect to our system.
We could hold it near a mic. Dr. Toma, can you hear me? Hello, Dr. Toma, are you able to hear me? Okay, I have one more, we'll try this. Hello, Dr. Toma, can you hear me?
I can, yeah, barely hear you, but
Okay.
you're not friendly anymore.
Okay, we can hear you great. So I will just make sure that whoever's speaking speaks up. Do you want to, Amanda, do you want to?
Sure. Dr. Toma, can you hear me?
I can't hear Amanda, no.
Okay, when you're questioning him, do you want to come?
Sure, and
just
stand
come
up.
Stand up here.
Yeah.
I'll give you this cart for your question.
Can you request you put this phone on speakerphone to hear that?
Yeah. Do you want to try and put your phone on speaker too? Because sometimes you can hear better if it's on speaker.
My phone is on speaker.
It is on speaker, perfect, okay.
Oh, now I can hear you.
Oh, okay, good.
Amanda, can you say something?
Dr. Toma, can you hear me? Hello?
Yes.
Is this okay?
I can hear you. Not as good as I heard the other woman, but I can hear you.
Dr. Toma, can you hear me now?
Yes.
Okay. Are we good? I have to stand here and ask this question.
I'll have you wear that.
Sorry.
Why don't you come over here and use the lapel mic and then see if that works better?
Just attach this.
Yeah. Sorry, I don't want to
Oh, no, that's okay.
touch you inappropriately.
That's okay. No, you're good.
How about that?
Dr. Toma, can you hear me?
Yeah, you're a little muffled, but I can hear you.
Okay. I think this can probably work. Sorry.
Okay, we'll note that we're back on the record and it looks like we have resolved the technical difficulties we were having with respect to Dr. Thomas. I'm going to turn it over again to Ms. Bass.
Thank you. Dr. Toma, can you please introduce yourself to the board?
Yes, my name is John Toma. I'm a licensed psychologist in Arizona.
Okay. And can you please talk to the board about your education, training, and your experience in clinical and forensic psychology?
Yes, I have a PhD in clinical psychology, and I have supplemental specialized training and supervision in forensic and neuropsychology.
Okay.
I graduated in 1995 with my doctorate, and I was licensed in Arizona in 1996. I've been practicing as a licensed psychologist for almost 26 years.
Thank you. Oh, I'm sorry, Dr. Toma. Go ahead.
In terms of my experience, I was at the state hospital for more than 7 years doing, at that time, it was all the forensic evaluations for the entire state, both the competency evaluations and the training or restoration, as well as the sanity evaluations and the Title 36 civil evaluations for the non-dangerous, non-repetitive offenders under the new GEI laws. My last position was head of the development and supervision of the forensic unit for psychological services.
Thanks, Dr. Toma. And In your forensic work, are you retained exclusively by defense lawyers, or is it, a combination of defense, prosecution, and court-appointed work?
So for probably 15 years, I was on the mental health expert list for Maricopa County and other counties, and I took primarily court-appointed cases at that time, or during those years, and I've since been retained either by the prosecution or by defense.
Okay. And when did you first become involved in Clarence Dixon's case?
In 2012, he'd already been convicted and sentenced to death. I was retained by his post-conviction attorney to assess his mental health and what his functioning level was.
Okay. And in 2012, what did your evaluation of Clarence entail?
So I spent approximately 14 hours interviewing and testing Mr. Dixon. I completed a full neuropsychological battery of tests, personality testing, and I did a fairly thorough social and clinical history.
Okay.
And then I reviewed the medical records that were provided, and that was, I believe, mostly everything that was available up to 2012.
Okay. Did you diagnose Clarence in 2012?
I did. I diagnosed him with, at that time, it was the DSM-4, was schizophrenia paranoid type.
And can you talk about what schizophrenia is?
Schizophrenia is a psychotic disorder. That would mean that he suffers from disturbances in thought, either process, how his thoughts flow, or content, which refers mainly to delusions, hallucinations, obsessions, and or disturbances in perception. Those are the primary markers for schizophrenia.
Okay. And we will talk more about how Clarence meets those criteria a little bit later on. But first, I wanted to ask if you could take us through Clarence's mental health history, starting with whether there were any factors that predisposed him to this sort of mental illness.
So at birth, he was born breech, and that resulted in some oxygen deprivation and a neurodevelopmental disorder, which was primarily pegged much later. And then he was subjected to emotional abuse and neglect, physical abuse and neglect. There was sexual exploitation when he was 16. And there was just a number of what we call childhood adverse experiences. And he was physically ill. He had a heart condition that resulted in difficulties walking, circulation in his legs and feet. So he was primarily isolated from family and peers, and pretty restricted socially. And he ended up having a heart surgery at the age of 13.
Okay. Can you talk about when schizophrenia tends to manifest?
So the first psychotic break, or when the illness becomes enduring, for men, it's usually the early to mid-20s.
Okay. And when did Clarence's schizophrenic symptoms begin to manifest?
So when he was 21 years old, he was a student at the Arizona State University. In 1977, there was this bizarre assault on a 15-year-old girl, and that's the case where he was found not guilty by reason of insanity. So it would have been at that time, around the age of 21, when the schizophrenia manifested itself.
Okay. And are you familiar, I'm sorry, Dr. Toma.
Right, it was just a very bizarre crime. He, as it was described by the mental health providers and then the records, it was just very bizarre.
And are you familiar with the mental health evaluations that were done by the court-appointed experts at that time?
Yes, so Judge O'Connor referred him to two psychiatrists who evaluated him, Dr. Tuckler, I believe his name is, and Dr. Bentheim. And they found him mentally incompetent, and they both diagnosed him with a schizophrenic spectrum disorder. They commented that he was quite depressed at the time, and so there was that overarching mental disorder as well.
Okay. So, and in connection with that bizarre incident in 1977, you mentioned Clarence is committed to the Arizona State Hospital. What happens after he is discharged from ASH?
He was found not guilty by reason of insanity, and Judge O'Connor directed the Maricopa County Attorney's Office to file, to commence proceedings for civil commitment.
And can you just say a little bit about the civil commitment process and when and under what circumstances that's initiated for someone?
Well, I mean, back then and now, they're very different. The processes are very different.
Okay.
My understanding back then was that, once you're found not guilty by reason of insanity, then they start civil commitment proceedings. Judge O'Connor found him to be gravely disabled and a danger to self and others. So the prosecutor would have then, at that time, filed a petition to have him civilly committed. He would have gone from the jail to the state hospital where they would have evaluated him.
Okay. Clarence's capital crime occurred on January 7th, 1978. And so at that point in time, he would have been in his early 20s. He would have been 21 or 22. And is that consistent with when, as you have explained, schizophrenia tends to manifest in men?
Yes, it is.
Okay.
It was 2 days after he was diagnosed with schizophrenia.
Okay.
Well, 2 days after the order came from Judge O'Connor, adjudicating him as not guilty by reason of insanity.
Okay.
So he still would have been suffering. We don't have a cure for that disorder, so he would have been suffering from that same disorder.
Okay.
At the time of the offense.
Okay. So he's found not guilty by reason of insanity on January 5th, 1978. The capital crime happens on January 7th, 2 days later, 1978. No civil commitment proceedings happen. He's just released. He's not hospitalized. Later on that same year, he goes on to commit a burglary and an aggravated assault of a woman that results in him getting sentenced to 15 years in the Department of Corrections. Is there anything in the Department of Corrections records that you've reviewed from that period that would support the fact that Clarence had schizophrenia around this time or was suffering from a kind of mental illness?
Yes, in 1981, the Department of Corrections psychologist described symptoms consistent with paranoid schizophrenic. He called it paranoid schizophrenic psychotic disorder. I found Mr. Dixon to be severely confused and disturbed.
Okay, and that's 1981, you said?
Yes.
Okay. So going...
I will say that the write-ups for some of the crime of the offense, there was some unusual, we'll say, behavior as well in that write-up.
Okay. And so going back to your 2012 diagnosis, can you walk us through how you reached the schizophrenia diagnosis for Clarence in 2012?
So to diagnose someone under the DSM-4, which was the manual at the time, with schizophrenia, that you needed to have two or more of the following: delusions, hallucinations, disorganized speech, grossly disorganized or catatonic behavior, and negative symptoms. And those are relating to affect and motivation. And those criteria, he met two. He had two of those based on my evaluation of him, the testing I obtained, the records I reviewed, and the observations I made during the evaluation. There's some exclusionary criteria and some other criteria causing, and they have to cause social and occupational dysfunction, and they can't be due to a medical condition. But he met the diagnostic criteria as it was outlined in the DSM-4. So the typical age of onset would be 21, 22 for him, early to mid 20s. I did some objective personality testing, the MMPI, and his test protocol was consistent with someone from schizophrenia, with schizophrenia. So that supported the observations and the history. And when I administered the Rorschach to him, which is an ambiguous test, it causes anxiety, he became very angry and agitated and accused me of trying to get into his brain, very paranoid during that, or after that test was done. So it was, there were observations supporting the diagnostic criteria, the record supported it, and I had objective test data as well. And I should add that I did malingering and tests of effort.
Okay, and was there any indication that Clarence was malingering?
No indication.
Okay, and just to clarify, that's something that you administered through objective testing. This was...
Yes, I administered a full neuropsych battery as well. Those are all objective tests, normed, multiple times over the years.
Okay. Can you talk about what impact living in a prison environment for 2/3 of his life at this point, since he was in his 20s, he's now 66, would have on his schizophrenic symptoms?
So the prison is actually, well, I'll just say this, back before we had medications, we developed state hospitals or psychiatric facilities based on the theory that if we reduce the stress and anxiety, then the symptoms would dissipate, and then they would be more amenable to treatment intervention. The symptoms are protective. Just for example, paranoia is a fear-based symptom, protects the individual, so that when you reduce stress and anxiety, the need for the symptoms diminishes. The prison is highly structured, prison and the jail system. And so we don't see the manifestation of the symptoms as significantly as we might see them if they're in a more stressful environment like out in the community.
Okay. And does the fact that Clarence's Department of Corrections medical records don't reflect that he has been treated with antipsychotic medication refute, or is that somehow inconsistent with him having schizophrenia?
No, treatment in the prison, and this is not a criticism, is only provided when, one, there's a previous history, or two, the inmate is either a danger to someone else or a danger to himself because of the symptoms. So they don't often come to attention of the mental health providers unless there are problems. And so his symptoms are not always apparent. He's delusional all the time, but they're not always apparent. The other piece I think that's really important in this case is people talk about him obsessing over that case at NAU. That's perseveration. We're also findings, some of his test results indicated frontal lobe damage. And that he's unable to shift his thoughts. So the reason for him, and up to the point I saw him in December, he was still perseverating on this very same topic. So we're talking many years where his thoughts are so rigid he can't shift them. That's the source of what people are calling obsessions, or his irrational thoughts, or his inability to, adequately represent himself or assist counsel. He can't shift his thinking. And this is not just on that particular issue. He has other, he can't shift his thoughts on other topics as well. That's the frontal lobe damage that I noted on the neuropsychological testing.
Okay. And Dr. Toma, can you also talk about the range of sort of symptomology with people who have schizophrenia? I think there may also be, lay misconceptions about how someone with schizophrenia would present. And also if you could talk about, Clarence's intelligence and how that factors into whether or not he is nonetheless schizophrenic and mentally ill.
Okay, so there are a lot of misconceptions about what people with mental disorders act like or look like. They're not all sitting on the street corner talking to themselves. Many schizophrenics whose primary symptoms are related to disturbances in thought, like delusions, you're not going to notice. You may not notice the symptoms or the disorder unless you actually confront the delusion itself. So in terms of his intelligence, he's actually, his IQ is within the average range. He had some, areas of high average abilities. And some of the test results suggested motor problems, but in general, he's verbal, smart, and he's also quite grandiose. Just the fact that he believes he could defend himself in a capital case should signify would signify to a mental health expert that A, he's either very grandiose, or B, he's got a personality disorder and he just wants to, use his time in jail and amuse himself. And that's not the case with Mr. Dixon. His thoughts are rigid, he perseverates, there's been follow-up and neuroimaging to support this, and he's quite delusional, both grandiose and paranoid.
Okay. Dr. Toma, do you believe that Clarence, I'm sorry, can you hear me?
Yes.
Okay. Do you believe that Clarence was suffering from schizophrenia at the time of Miss Bowden's murder?
Yes. I believe that, we don't have a cure for that disorder. So, and I've seen continuous, observations or data from the first two evaluations that were done in 1977, 78, through when I saw him, and then when I tested him, and then when I last saw him, December 22nd of 2021, which is quite recent, he was still, one, perseverating, and two, paranoid. He has no insight into his mental illness, meaning that he doesn't believe he has one. And that's not atypical of people with mental illness. They typically don't perceive themselves to be mentally ill. The delusions are very real to them. The hallucinations are very real to them. So it's not uncommon for a lack of insight to be actually a part of that disorder.
Okay. When you saw Clarence in, you said late December of 2021, did you notice any changes in him? I know you have just talked about how he's still perseverating, but were there any differences that you noted?
Yes, because physically, he is very frail. He's underweight. He is blind, so he can't see at all now. But it's just his frailness and he's just very skinny and he has a number of medical conditions that I'm aware of from the record.
Okay.
But he just seemed very frail. He was paranoid and he's blind now.
Do you believe that Clarence presents a danger at this point to anyone in the prison environment?
No, I don't believe he's a danger, either to himself or others.
Okay. Thanks, Dr. Toma. If you all have questions.
Any questions?
I have one.
Fellow board members for Dr. Toma, Mr. Quinones?
Thank you, Ms. Mendez, and I'll keep it short. Dr. Toma,
Yeah,
do you know if Dr. Marchildon was treating Mr. Dixon with psych meds when he was in ASH back in late 1977, early 1978?
I'm sorry, can you repeat that? It's hard, you're muffled a little bit.
Do you know if Dr. Marchildon was treating Mr. Dixon with psych meds in ASH back in late 1977, early 1978?
My recollection was that he was treated to be restored to competency. And then that I saw no evidence of treatment after he was returned to court.
I'm not sure what that means. Was he on a medication?
I believe he was receiving medication at the state hospital for those few weeks that he was there.
So it's possibly he was still treated with medication when he raped and murdered Ms. Bowden.
Well, he wouldn't have had access to medication.
2 days later. 2 days later, sir? It was 2 days after he was released. So is it possible that he was still being treated with medication at that time?
I don't believe that he had access to medication once he left the jail.
Thank you, sir.
He may have had, there may have been some effects of the medications that he had been receiving before that.
Thank you, sir.
I'm not a physician, so I don't know what their half-life is.
And Mr. Quinones, if I could just add on to that. So the records from the Arizona State Hospital show that Mr. Dixon was prescribed Thorazine, but he was only in the Arizona State Hospital from September of 1977 until November. So he was actually not in the hospital.
Okay, thank you.
He was not in the hospital.
Thank you for that answer.
Yes, I hope that clarifies.
Yes, it does.
Okay.
So he was being held by Maricopa County Corrections from point A to point B, or
released on his own recognizance, I believe. He was not being detained.
thank you.
All right, any other questions for Dr. Toma?
Okay, thank you.
Can we let Dr. Toma disconnect, or do you want him to stay on?
I think we can let Dr. Toma disconnect if you all have no other questions for him. Okay, thank you, Dr. Toma.
We thank you for participating in the hearing today. Thank you, sir.
Thank you, sir.
Thank you.
All right. Ms. Bass, did you have another speaker that you wanted to present? Give me 1 second.
We're going to ask Emily Skinner from the Arizona Capital Representation Project to address the board.
And she can just speak from the podium, wherever you're comfortable.
Good morning. My name is Emily Skinner, and I speak to you today on behalf of the Arizona Capital Representation Project, or ACRP. We are a nonprofit legal resource center dedicated to improving the quality of representation afforded to capital defendants in Arizona. Since 1988, our office has provided direct representation, consulting, and training to capital defense teams, and we have monitored capital cases at all stages, from trial through the execution. In light of this history, ACRP is uniquely qualified to comment on Mr. Dixon's case and his request for clemency. There's no question that in 1978, Mr. Dixon took the life of Ms. Bowden and that she and her family suffered an unimaginable loss. Nearly 45 years later, however, it does not serve justice to execute Mr. Dixon, an Indigenous person who is aged, physically disabled, and mentally incompetent. Mr. Dixon has demonstrated over decades that he can be housed safely within the Arizona Department of Corrections. Mr. Dixon's advanced age, his poor health, and his exemplary prison record make him an excellent candidate for commutation so that he may serve out a life sentence in custody. At a minimum, this board should grant a reprieve to allow Mr. Dixon to continue to litigate whether he is legally competent for execution. The board should take into consideration that Mr. Dixon's serious mental illness, along with failures of his defense team and the court, resulted in Mr. Dixon being sentenced to death without the jury hearing any of the compelling mitigation that is before the board today. Mr. Dixon has a long and well-documented history of mental illness, including schizophrenia, as well as legal findings of mental incompetency and insanity by Justice, then Judge Sandra Day O'Connor in earlier proceedings. Despite this record, he was permitted to represent himself at a capital murder trial without his trial counsel requesting or the court ordering a competency evaluation. He was then appointed advisory counsel who has been identified in national media as being one of the worst capital defense lawyers in the country because of his poor performance in capital cases, including missing court, failing to visit his clients, and also fraudulent billing practices. Representing himself, Mr. Dixon was deprived of the scorched earth mitigation investigation that capital defense lawyers are required to conduct under the prevailing professional guidelines. A mitigation investigation requires the team to interview family, friends, neighbors, employers, teachers, and anyone else who may possess evidence on the defendant's background and life history. Without the proper guidance of qualified capital counsel, the mitigation specialist here, who you heard from, did not interview a single social history witness or collect any life history records. Without the investigation having been conducted, Mr. Dixon offered a single witness in the mitigation phase, and not surprisingly, after only an hour of deliberations, the jurors returned a death verdict. A likely contributor to the court and defense counsel's failure to protect an incompetent man from all but guaranteeing a death sentence for himself is the fact that at the time Mr. Dixon's case went to trial in 2007 and 2008, Arizona was in a capital case crisis. There was more than 150 capital cases pending across the state and 120 in Maricopa County alone in January 2008. Disbarred Maricopa County Attorney Andrew Thomas doubled the number of death notices in his office, and he overwhelmed the criminal justice system and especially the indigent defense system. Such conditions led to extreme miscarriages of justice, including Mr. Dixon proceeding to trial incompetent, unrepresented, and without the skills to investigate or present a case for life. Were this case pending today, the defense team would surely have had more time and resources and would be able to identify Mr. Dixon's delusions as evidence of his incompetence. Lastly, this board should consider that Mr. Dixon is a member of the Navajo Nation whose government opposes the death penalty as inconsistent with its culture and values. The death penalty has been used disproportionately against people of color across death sentencing jurisdictions and in Arizona specifically. The data is clear that this ultimate punishment is not reserved for the worst of the worst, but is instead a perpetuation of racial inequality. The board should grant Mr. Dixon clemency to stop racial disparity in the use of the death penalty and to respect the culture of the Navajo Nation. On many occasions, state clemency boards and governors have granted clemency in circumstances similar to those present here. In 2017, the Virginia governor commuted the death sentence of William Burns to life without the possibility of parole, where evidence showed Mr. Burns' mental illness rendered him incompetent and unlikely to regain competency. In 2019, Kentucky Governor Bevin commuted Gregory Wilson's death sentence to life with the possibility of parole because he was represented at trial and sentencing by a lawyer who presented no evidence to support a lesser penalty than death. And in 2018, Ohio Governor John Kasich commuted Raymond Tibbetts' death sentence to life as a result of fundamental flaws in the sentencing phase of his trial, which prevented the jury from making an informed decision about whether Mr. Tibbetts deserved the death penalty. It is beyond question that the victim's death was unspeakably senseless and tragic, and I wish to extend my deepest condolences to her loved ones. But this horrific tragedy is not grounds to create another by executing a gravely ill, disabled, and incompetent man. I ask that you give full consideration to Mr. Dixon's incompetence, his unjust trial and sentencing hearing, and the fact that he has a decades-long record proving he can be safely confined within the prison. On behalf of the Arizona Capital Representation Project, I urge you to commute Mr. Dixon's sentence or at a minimum to grant a reprieve.
Any questions for Ms. Skinner? All right, thank you. We appreciate your participation.
That concludes the portion with respect to the request for a commutation. We will briefly talk about the grounds on which we're seeking a reprieve, and I will turn it over to Mr. Sandman.
Okay. Whenever you're ready, Mr. Sandman.
We sort of digressed a little earlier into a discussion about this by the chair's question about, do we believe that Mr. Dixon is incompetent at the present time to be executed, and we believe that's the case. The judge, our Pinal County Superior Court judge, believes that there's prima facie evidence that Mr. Dixon is incompetent to be executed. And we would ask this court to grant a reprieve so that that question can be fully litigated through the courts.
Mr. Sandman, can you explain to the board the standard for finding that a person is not competent to be executed? In other words, what does the Pinal County judge have to be able to find?
The focus of our claim, and this is part of the element that is required to be established, is that the prisoner has to have a rational understanding of the state's rationale for the execution. So it's not whether he knows that he has a sentence of death. It's not that he knows that an execution has been pending related to that sentence and conviction. He has to have a rational understanding of the state's rationale. And I believe we supplied you with a copy of the report from Dr. Ernesto-Patino, but it's the doctor's finding that he doesn't have that rational understanding, that he still fervently believes that somewhere along the line, some judicial officer who's not quote unquote corrupt will find that he was wrongfully arrested in 1985 and that justice will be done, that he will not only be released from prison on this case, but on the earlier cases that he's serving a life sentence on. And that's really the core of the claim. And his belief system is, it's based in a psychotic delusion that he's had for probably over 30 years now.
So to put it more simply, he has to understand why he has received the death penalty and for which case it was, and that it was not this case in 1985 involving the NAU police that he has fixated on, that it was in fact the earlier murder and rape of Ms. Bowden. That he has to be able to understand that that's why he received the death penalty. Is that correct?
Yes, and we have provided the board with a copy of Judge Olson's order from yesterday where he unpacks the competency to be executed standard.
We just received it.
Okay.
So we'll review that over the lunch break.
Thank you. And that explains the fact that under the governing Supreme Court cases, Ford versus Wainwright and Panetti versus Quarterman, the inquiry is not limited to awareness of, the crime happened here and I'm being executed because I was found guilty of this crime, but rather requires probing a defendant's understanding and their beliefs around why they're going to be killed by the state. There are cases where defendants have been able to verbalize an awareness that I was convicted of this crime and I'm going to be executed in connection with that crime. And the Supreme Court in Panetti made it clear that awareness of A to B is not enough. If the underlying beliefs around why this process is happening are contaminated by delusions that are also occurring in the framework of a mental illness, in which case, that is what would qualify for an unrational understanding. I hope that answers your question.
It does. Any other questions for Mr. Sandman or Ms. Bass from any of my fellow board members? All right, and you have concluded your presentation, correct?
Yes, ma'am.
Okay, so I think this is a good time for us. It's 11:55. So let's go ahead now and take our 45-minute lunch recess. And when we come back, we will hear from the state and from the victim and victim advocate. And then you, Ms. Bass, will have the last word. You and/or other members of your team will have the last word before the board goes into discussion. All right, so we will stand at recess and we will return here at approximately 12:40. Thank you, everyone.
Okay, cool. What is the issue? Yeah. Yeah, you danced. Yeah, yeah. Nice to meet you. Good to meet you. Yeah, this is Future. She's the. Yeah, we met. He said, oh, yeah, yeah. So where are you all based? We're just. Okay. Yeah, okay, cool. Just in September, before that, I was with KJ. Yeah, we were there for 8 years. Oh, really? Yeah. Yeah, yeah. We can go. There, and A lot of other people, yeah. Yeah. Welcome to free trade. Thank you.
I can share my food, you share your food. You want a banana?
Yeah, we're fine. A lot of people leave plus the public in the past year, so a lot of turnover, but a lot of people coming. That's good.
It's so cold here, I'm gonna go outside.
We are coming official, but I'm pretty sure you can follow it up on social media. I know you are actually. I just on my phone too much, but other than, yeah, May will be at the state hospital. We have, some from the Catholic Diocese coming, we have, mental health speaker, Dale Ash.
Oh, yeah. We probably did. Yeah.
You want to, where's the candy?
It's at 6 o'clock,
An old bullet candy.
6 to 7, probably around the over what we're doing.
We did, I mean, I knew he's everywhere, so I also saw him in the town, yeah. He's a nice, personable guy. So. He was, I didn't know he was. Yeah, right, well, car accident, I guess, right, so it's sad, terrible, everybody was really shocked, there's like, you always see a lot of outpouring of grief in the past, but, yeah, that was like, I've never seen anything like that, it really touched a lot of people. Yeah. You want to eat or no? I ain't gonna type some stuff, I get it. If I don't type something, I'll get all overwhelmed, so. Nice to meet you.
Nice to meet you as well. Thanks for being here.
Oh, yeah, of course.
Morning.
They showed me at the.
Oh, great. Yeah, after this, it'll kind of get moved to the next call, right? So we can.
Yeah, I understand, yeah, okay, cool. Well, we'll touch base later. Oh, you sit down. Ma'am, are you standing? Yeah. Are you standing? Yeah.
Monitor the stream.
Okay.
Settings are different for everybody, so it's hard to explain something.
Has everybody been fixed and soon, but you know, the decision coming from
It's just there's no way to visualize what where his settings are. It's like, it's great.
Well, you can
Freezing here. It's like 10-degree difference.
There's some kind of low feedback.
Are you all moving too when they do all the building reorganization and all that? Yeah.
Clemency.
Where do you think you'll end up? Okay. Be a huge deal, right? When that's supposed to happen? Like, is this building and the DOC building? Wow. Okay.
So you got the vote for it.
$12:35, is that right?
12:40.
12:40, okay, thank you so much. cold here. What time are we supposed to start up again?
Yeah, yeah.
From Michigan also, and then some of this cool next here.
I know he's just moving to big one. I want him to take over. Let's see, yeah. I know. We just said it right here.
That's what I was gonna do.
Is it okay to put something right here? But I want to make sure you feel like it's.
Yes. No. Okay.
I was gonna say, which ones am I like? I don't think I'm. Did you see on your Something like I agree that. I don't think it's very fair. Oh, I think it's like.
Okay, okay.
Right, he's on his way.
He was right behind me. Here he comes.
Okay. All right, so the record will reflect, and we are on the record, correct, Emily? So thank you. All right, the record will reflect that following the lunch break, we're back on the record. In the matter for the board to consider recommendation of commutation of sentence to reprieve for Mr. Clemency and C number 038977. And before taking the lunch break, we had just, concluded with Mr. Dixon's legal team's presentation of their case. We're going to turn now shortly to the state's presentation of their case. But before we do that, I did have an opportunity, as did I'm sure my colleagues, to read the Pinal County Court's reconsideration order. And I did have one additional question for you, Ms. Bass, and then we're going to turn it over to the state. And so my question for you, Ms. Bass, is that was triggered from reading the Judge Carter Olson's ruling. Your client has submitted through a grievance, for lack of a better word, process or request process at DOC, a number of requests over the past year. And over the past 6 months, those have increased to 1 or 2 a month. There were several in February of this year. Where he specifically references the execution and seems to have a very good understanding of the execution, that it's approaching and seems to understand why. And so I just wanted to give you an opportunity to reconcile that or explain that.
Sure. And our position, supported by the report of our psychiatrist, Dr. Mezquipitino, as well as his addendum, which we put into the record before the Pinal County Court, explains that that is evidence of awareness and not of understanding. Because when you probe Clarence's underlying beliefs around why he is going to be killed, he believes it's directly related to this judicial conspiracy to deny him relief on this factually baseless, unrelated NAU issue. And so his awareness that he is scheduled to be executed for being convicted of Miss Bowden's murder is, in our view, evidence of awareness, not understanding. And that comes through in his grievances and in some of his other writings where he can verbalize, and Dr. Mezquipitino explains this, an awareness of what is happening. But the Supreme Court said in Panetti that the Eighth Amendment requires more than just awareness. It requires rational, fact-based understanding.
And so even though in the trial, his one of his defenses, or his primary defense, was that Dina's boyfriend had killed her, and even though he still present day continues to assert that as an explanation for why she was murdered, that this other person who had motive had done it, in your mind, that is still only evidence of awareness and not of understanding.
Clarence's defense at trial was the defense of a mentally ill schizophrenic man. Now, whether or not that is the defense his lawyers, Mr. Simpson, would have mounted for him, you heard today that that's not what they would have pursued. They would have pursued an insanity defense. And so I don't think it's necessarily accurate to say that his attempt to, give the jury a theory that Mr. Baines had to have committed this crime is necessarily evidence of incompetence in itself. I think that is a function of his botched attempt to represent himself and to present a theory of defense. I think if you look at Dr. Vega's report, which the county attorney has put into the record, I think it's Exhibit 13, he does say, and I think it's telling, that Mr. Dixon does not have he doesn't remember this crime. And Dr. Vega specifically opines that Mr. Dixon's claim to not remember is genuine. Dr. Vega also notes Mr. Dixon's delusions. And so, Mr. Dixon doesn't remember what happened. He doesn't have a memory of what occurred. And so, I think what we would maintain is that his writings around, why he has not gotten relief, his theory that Michael Baines carried out this crime, is indicia of awareness that he's being accused of something, but not of real rational understanding for why this is happening.
All right, any questions based on those questions that I had for Ms. Bass? Okay, all right, so Mr. Dixon's counsel, having concluded their presentation, will turn now to the state, and I understand that we're beginning with Mr. Mordino go ahead, Mr. Imbordino, whenever you're ready.
Is this on?
Green light, sir.
It is now.
Right.
Are you able to hear me?
We can hear you.
Okay, thank you. Thanks for allowing me to address the board. I appreciate it. I want to preface my remarks by saying that the things that I'm going to talk about here briefly this afternoon are not meant in an effort to rewrite history. They're not meant to suggest that Mr. Simpson doesn't have experience or isn't entitled to his opinions, or to suggest that just now retired Justice O'Connor was or wasn't a good trial judge. But there are some things that I think the picture that has been attempted to be painted here this morning are just not accurate. Ms. Dahl and Mr. Schneider are going to address some of those things as well. But I've appeared here before, of course. I think I've said this to you all before. You can tell I've been around a long time. Mr. Simpson was a bailiff for Judge O'Connor. I tried cases in front of Judge O'Connor. It's not about me, but, and yes, she had wisdom, but no greater or less than any other trial judge in Maricopa County at that time. Trial Judge O'Connor made rulings in the cases that I tried in her court that I today think are wrong, which to me sort of goes to some of the questions you've asked about, well, aren't there lawyers who take positions that are legally wrong, but they think are right? And that's true. And judges aren't always right either. But to put this in perspective, if we go back to the assault case that happened when this inmate began his criminal history here in Maricopa County, as I recall, was sometime in the summer of 1977. And if everyone looks at the records that you have, I think it's important that people here in the room understand this. He was not in custody pending trial. He was not in custody. A judge could have kept him in custody, but she didn't. He was initially deemed to be not competent to stand trial, and he was committed to the state hospital to be restored to competency. I mean, we still have those same procedures today. As the Honorable Chairperson knows, as I recall, you were a commissioner. I'm sure you worked on some of these types of cases. But he was restored. The state hospital determined he was competent. Ms. Dahl, I think, is going to talk about the doctor from the state hospital who also determined that he did not have a mental illness at that time. You know, Justice O'Connor found him to be competent to stand trial, and he remained out of custody pending trial. Much was made this morning, at least, unless I misinterpreted it, was that Judge O'Connor thought this man was extremely dangerous and should not be allowed in the community. And nothing is further from the truth if you look at the record. Again, we cannot rewrite history. I do not know why Paul Lazarus decided to submit this case to Judge O'Connor for a finding of not guilty by reason of insanity. He did. But what I think is important for everybody here to know, when I read Dr. Tuckler's and Dr. Benheim's reports, they do not conclude that he was insane at the time of the assault. They suggest that he might have been. The point I'm trying to make here is there was no contested hearing where the state called psychologist or psychiatrist to opine about his mental status. We don't do it as often today, but in 1977 and 1978, it wasn't that unusual for there to be submissions to a trial judge in a situation like this. And again, what's done is done. But any judicial officer presented with a waiver of a jury trial by a competent defendant, the state waiving a jury trial, the state not presenting any evidence to the contrary, with these two reports, the judge is basically being told, we're fine with you finding him not guilty by reason of insanity for the crime that occurred in July of 1977. Unrelated to the murder that he committed. There's been reference like 2 days later, he commits a murder after a trial judge found him to be insane. That's not true. It's just not true. When you look at the records, she left him out of custody. The statute at the time required a judge, if they found a defendant not guilty by reason of insanity, to commit them to a mental health facility. She did not do that. Whether it's right or wrong, whether she chose the wrong statute to refer to, there's no way to reconstruct that, and it wouldn't matter because that's what happened. But to suggest that this inmate committed a murder when we all know that he was insane, and even Judge O'Connor thought he was insane, is just nonsense. It's just not true. The other thing I would point out is that even under the statutes in existence at the time, if we wanted to have somebody civilly committed, we had to file a petition. A mental health court case number would be assigned. We didn't have the ability to go out and arrest him and put him in jail pending our filing a petition to have him civilly committed, even assuming we had the evidence to do it. But that's been suggested here today that that's what we should have done. And that simply was not the law. The only way, and psychologists and psychiatrists can opine that 20 or 30 or 40 years ago, in their opinion, an inmate was insane at the time of the offense. When they weren't there, there are no witnesses to the offense. And all we know is that this inmate broke into this young woman's home, sexually assaulted her, stabbed her, and strangled her to death. There is no evidence there is no evidence from anybody that witnessed this, that saw him that day, that can relate that to any mental illness he might have had, if indeed he did. The other thing, the last thing that I wanted to talk about was, and I'm trying not to repeat what I believe Mr. Schneider and Ms. Dahl are going to discuss, but having tried a number of cases over the years, there's been a lot of discussion about how no mitigation was presented in this case. This defendant, and I think Ms. Dahl is going to discuss this in some detail, what the law requires. But if a defendant is allowed to represent himself, he gets to choose. He has a constitutional right to do that. He gets to choose how to conduct his trial. And that's what happened here. But what I think is important, maybe you don't. I prosecuted a fellow by the name of Kevin Roscoe a number of years ago. Kidnapped, sexually assaulted, murdered a 7-year-old girl. He had Roland Steinle as his defense attorney. Roland Steinle became a trial judge. Mr. Roscoe chose not to present mitigation. He made that decision.
even though represented by counsel. Dale Hausner, and there are a lot of examples of it. Dale Hausner, one of the serial shooters, was found guilty of 6 murders. He had counsel. Over their objection, he chose not to present mitigation. He chose. So the point I'm trying to make here is that this inmate chose to represent himself. He chose to control the trial. Judge Klein, from the record that I'm aware of, did the best that he could to make sure that that defendant's rights were honored. He controlled the trial. To suggest that Judge Klein was not in a position to know that there was a problem and chose to ignore it is not, again, not a legal term, it's nonsense. If you knew Judge Klein. In any event, as I said, Ms. Dahl and Mr. Schneider will address many other issues that they believe are important. If you have any questions of me, I'm happy to answer them as best I can.
Thank you, Mr. Impordino. Any questions for Mr. Impordino at this time? All right, there are no questions. Thank you. Let me see here. So Mr. Schneider is going to speak next, correct?
Yes.
And I'm saying your name correctly?
Yes.
Okay, go ahead, Mr. Schneider.
Thank you. As my colleague addressed the 1970s claims of competency in some respect, I'd like to address briefly the current claims of competency and their request for clemency and/or reprieve. As we speak, the inmates' claims are being adjudicated in accordance with Arizona law in an Arizona courtroom. That is the proper venue to adjudicate the inmate's claims with regard to his contemporaneous competency. The state would not ask this board to second guess the Supreme Court of our state, and we don't think it appropriate for the inmate to ask this board to second guess the Supreme Court of this state either. This board can, in good conscience, deny the request for commutation and reprieve. The state, through the county attorney's office, would like to note the following. We look to the clemency application and most of the presentation today. It's cherry-picked data that just a moment ago, through Mr. Impordino, shed additional light on some of the claims, some of the representations, some of the references. This inmate is a predator. Exhibit 2 of the state's letter to this board outlines horrific crimes that this inmate committed. Not only the one that we are here for, the so-called elephant in the room, but in his pre-sentence report for one of the other predatory offenses, he outlines, I believe it is 4 separate instances of invading, terrorizing members of our community's most personal and private affairs. The records from the Department of Corrections that are before the board, the inmate admitted to 4 separate instances of rape. So for a endeavor seeking mercy, which that is absolutely the role of this board, among others, to have no acknowledgement in the presentation of what has the inmate done to correct his behavior, what remorse does the inmate have for his predatory crimes, we've seen nothing of and we've heard no mention of. By his own admission, he's a serial rapist. We've focused a lot on this claim that the advocates for the inmate characterize as delusions. The inmate's legal opinion as to how the evidence against him was procured and used is characterized as a delusion. It's as if the inmate's right to represent himself, make decisions about himself, guide his own defense, are all ignored, and somebody sweeps in and says, "No, we know it better. We know what you really meant. We know what you really want." How is that respectful to Mr. Dixon's decisions, his constitutional rights, the decisions that he made, the decisions that the trial court, that the inferior appellate courts all made, all reviewed, every decision has been scrutinized, every record scoured, all affirmed on appeal to the highest level. The representation that the inmate's opinion as to how the evidence, the key evidence against him was procured as delusion is not even recognized by Arizona law. Now, it may not be before this board, but our colleagues with the Attorney General's office provided the court in Pinal County some very apt references to very similar circumstances. Some very limited quotes with regard to case law I think are appropriate, may assist the board in framing properly the inmate's suggestions that his legal position is just a delusion. Two federal courts out of the circuit court, Seventh Circuit, quote, criminal defendants often insist on asserting defenses with little basis in law, particularly where, as here, there is substantial evidence of their guilt. Quote continues, adherence to bizarre legal theories, whether they are sincerely held or advanced only to annoy the other side, end quote, does not imply mental instability. That's exactly what we have here. And when one actually reads the Good or Goudet, Good v. Alfred appellate court decision, which is apparently the bane of the inmate's existence, depending on one's perspective, there was actually a court in our state that ruled in favor or consistent with what the inmate's legal position is. That just was overruled by a superior court and has never been challenged in any way. So the inmate's entitled to have the inmate's opinions, but he certainly orchestrated it very well. He identified the critical evidence against him, the DNA evidence. He challenged it at the trial court by filing a motion to suppress. He challenged the denial by way of an appeal. Recognizing that this was the damning evidence against him, he utilized the tools as a criminal defendant, prioritized what in his mind was most important to him, and he pursued it to exhaustion. And that is, the appellate courts just didn't decide to overrule it. So to suggest that his legal position, which he chose to press, is a delusion is ignoring the definition of delusion. And it is confusing the word delusion with opinion. And that's not grounds to disrupt, overthrow, overturn decades of legal conclusions and review that this particular case has had. The advocates for the inmate spent a great deal of time talking about his mental health, but they didn't provide the board, or at least reference the board in any detail, the Arizona State Hospital records from this very time that Mr. Imbordino referenced. I'll read very quickly. This is October 26, 1977. The Arizona State Hospital physician, Dr. John Marchildon, pardon me if I'm mispronouncing that, he determined the inmate, quote, is competent to stand trial, end quote. And the inmate, quote, has displayed no behavior or ideation which would indicate mental illness, end quote. 73 days later, he raped and murdered Deanna Bowden. So we have mental health professionals contemporaneous to this horrific crime determining the inmate had no mental illness. From the presentation this morning, I think it's appropriate to note that the Board of Executive Clemency exists according to law as it should, but this is not the forum to attack the American justice system. This is not the forum to attack Arizona law. There is another building very close to here, the state legislature, where laws are debated and passed. That would be the forum to petition the government to change the law. But for advocates to come in here, attack the law, that there is no dispute, is in fact the law, really seems to not be focused on the true nature of this board, and that is to grant mercy, to grant reprieve in appropriate cases as the board sees fit. But this collateral attack on our way of justice, our system of justice, seems to not be the proper focus for this board's attention. And with regard to the comments by Mr. Simpson, never worked with the gentleman. I think this is the first time ever come across him. but I am also a member of the Arizona State Bar. He never informed the court, as far as his comments this morning, with regard to this awareness or recognition that he now professes. So if that's correct, and Mr. Simpson's opinions are in fact genuine, he lived with this serious mischaracterization of justice, not only the death sentence, but Mr. Simpson's characterization that this inmate couldn't possibly have even represented himself would call into question the validity of his conviction, his underlying conviction, not just the penalty. So only when the inmate is facing the gallows, death sentence actually being imposed, he recognizes this huge error. And I don't recall specifically, I believe it was board member Quinones who asked, well, when did you realize this? And he says it was when he gave up the case. So guilt had not been established. What, if any, proactive steps would he have taken? I mean, for a member of the state bar to be aware that an injustice was occurring and they were firmly convinced in that belief, one would expect that some proactive steps would be taken. The advocates this morning represented that the inmate thinks everything's just going to be okay. He's going to win. Everything's going to be fine. Well, the inmate's comments to Mr. Vega just a few weeks ago seriously questioned that. He told Mr. Vega that he was sad because he was going to be put to death in a few weeks. And the inmate's comments reflect that the inmate is, in fact, fully aware that he is to be executed soon and why. So the notion that, oh, the inmate is in this delusional state and thinks everything's going to be okay, once again, is contradicted by the record before the board. This particular inmate, prior to the determination of guilt, was represented by 4 capital qualified attorneys, one of which was Mr. Simpson, another of which is Ms. Vicki Lyles, still practicing, still well known. Actually, I have her on a case now that is yet to be tried. So the suggestion would be not a failure by Mr. Simpson as he falls on the sword and repeatedly stated, but would be that these 4 attorneys with probably close to 100 years of experience combined by the time the trial occurred, all missed this. And it slipped through the cracks, as well as the trial court. So that it rather seems self-serving that no one filed any request for Rule 11. None of these attorneys raised this issue that now the advocates claim to be overwhelmingly obvious. With regard to the defense preparation, there was a suggestion. The word wasn't used, the term wasn't used that the inmate was railroaded, but that was the suggestion, that he just didn't have enough time to get ready. The trial was shambles. I'm paraphrasing and characterizing, but this inmate was charged in 2002 and he was tried in 2005. So we had years of preparation. 2007, thank you. Excuse me, even more, 5 years of preparation. We heard from the mitigation specialist that that gentleman was not the first mitigation specialist, but that someone else had gathered all the records and compiled the data. So this inmate had teams, plural, advocating on his behalf before he made the decision to represent himself. None of the pleadings that would have been triggered that the advocates now claim were necessary were filed. We also heard from the mitigation specialist that Rule 11, which is the rule that deals with competency in a pretrial, post-trial kind of phase that we're discussing this afternoon, that he had those discussions with advisory counsel, Mr. Countryman and Mr. Carr. So we know that that was discussed, and they, by way of not filing anything, did not believe that either one of their ethical responsibilities were triggered to file any particular claim to call the judicial branch to come in and intervene. This man is not competent to represent himself. I know he wants to, but I am duty bound by as a member of the state bar to file something. That didn't happen. So that's telling, folks. It's very telling. So the suggestion that this all just got missed and it's a miscarriage of justice is, as Mr. Imbardino referenced, sort of rewriting history. We also heard from an advocate that when asked if he was found not guilty by reason of insanity or guilty except insane, what would have happened to him? I believe there was a characterization that he would have never gotten out. And I believe that was by I'm sorry, Carrie Sandman. I apologize if I'm mispronouncing that. Well, that's incorrect. We can provide the board, if necessary, a list of names where we are aware of, and I mean we, the Maricopa County Attorney's Office, there are multiple murderers living on the streets in our community, even after they have been or were charged with murder, that would have been given life sentences but are out in the community because of what is now known as guilty except insane, at the time is referenced as not guilty by reason of insanity. So the suggestion that the inmate would, quote, never have gotten out is not accurate. With regard to the suggestions of the inmate's current competency, we did attach as Exhibit 13 the Carlos Vega examination, and it undermines essentially all of Dr. Toma's suggestions. And you'll see from Dr. Toma's 2012 report and his 2022 report, there is some evolution in the conclusions. But the 2022 report from Mr. Vega outlines that the inmate is alert, he's oriented, he knows what's happening. He reports his weight is 145 pounds, which may seem as a trivial matter compared to the gravity of what we're discussing, but that weight of the inmate just earlier this month is 145 pounds, directly contradicts the representations of his advocates that he's wasting away or he has wasting syndrome and he's barely over 100 pounds. The inmate represents that he's 145 pounds. He's clearly aware of what is happening because he is talking, and you get this from the report. He references being depressed or sad because of his impending execution, as we've already discussed, or at least his impending execution date, But this inmate is astute as to current matters of political discourse. He has opinions about the former president. He has opinions about the current president, not just like him, hate him, about matters that are being discussed in the current political realm as to the appropriateness of the current presidential administration and its dispatching of its duties. So this inmate is clearly aware of what is happening, despite being advanced in age, despite being visually challenged. But the law applies to all. Equal justice under law is a hallmark of our system of justice, and it applies to folks who are senior citizens, and it applies to folks who may be disabled. Equal justice under law. But when we really dig down to it, when talking about this time period, meaning the homicide with which we are here, the inmate describes that this was simply an alcoholic blackout, or gives language to the effect of, at that time, I was regularly blacking out. And that's important, because if that is in fact his position, or what the evidence would support, then all of the claims about competency and his mental illness would not be legally available to him. We have a statute, 13503, which is largely the same back then as it is today, which essentially says if you're high on drugs or alcohol that you voluntarily consume, you don't have the ability to challenge the mental state. So if he is truly abusing alcohol, as he contends that he was, the avenues of defenses in accordance with Arizona law are not as clear-cut as the advocates for the inmate would lead you to believe. It would certainly negate not guilty by reason of insanity, because you can't be insane and drunk, essentially. I'm boiling things down to the utmost simplicity in my effort to be respectful of your time. But we also see that this inmate is not delusional, because he's able to articulate what consequences are and what decisions he would make impacting him. There's the back and forth about the address book, which may seem like the silliest thing in the world. But if he's truly delusional, then why would the inmate recognize, and I'm paraphrasing, perhaps I just misplaced it. Yes, he has a lot of angst towards the Department of Corrections, but in the change of, it actually could have been my fault too, he states to Dr. Vega, that in and of itself, that subtle change of it's not them against me, it could just be me, illustrates he does not have this pervasive mental illness that is attempting to be presented to the board. The advocates this morning really glossed over a critical factor, a critical missing part of their presentation, of their representations with regard to the inmate and his capacity in 2022. He's never been treated for any psychiatric or psychotic diagnosis in the Department of Corrections. This inmate has been with them for 40 years. I'm rounding my numbers, but there's no records, at least not that the state has been presented for this tribunal, indicating that he's had any psychotic diagnosis, any psychotic medication, any psychotic treatment by the Department of Corrections, which is responsible for his health, safety, care. There's been no suggestion that he's not getting things that he needs and he's desperately trying to get psychotic medication, for example. And the advocates gloss over that. Well, he's in such a structured environment. That's why it's not really manifesting itself. Well, then would submit to the board, it must not be that serious of a challenge if he's able to hold it all together, for lack of a better term. The Department of Corrections responsibly houses the various inmates that it has to house. They would be all over this if there were, in fact, genuine, substantial evidence of a psychotic diagnosis. No records have been presented. There's no evidence that he is experiencing active symptoms of schizophrenia, that it impairs his ability to function, such as the advocates are presenting. To grant reprieve or clemency would require the board to ignore all prior appeals that have already been addressed, that the description of the 1978 case, the alcoholic blackout, as I've already addressed, and prior counsel statements don't add up. Whether or not the inmate's ability to represent himself was at issue, if they genuinely felt there was a inability in the sense of a competency issue for him to represent himself, they would have been duty bound to affirmatively have acted. None of them did so. So the suggestion, as I've already articulated, that it was just a slip up, is a little bit of revisionist history. The characterization of the terminology that this inmate is SMI, seriously mentally ill, that is not a diagnosis. It's a description of a category of folks. So simply having that description doesn't mean they suffer or that a person has a particular diagnosis. Excuse me. It also would ignore the role of the trial court in all this, not an advocate, an independent minister of justice who did thorough colloquies with the inmate and would never have permitted an obvious injustice to occur in the courtroom. Whether or not the decision to present not guilty by reason of insanity in the trial court at the guilt phase would have been a decision for the defense, either the accused himself, if he was representing himself, or the defense team. That was a strategic decision to not press that. That's the way the law works. So to second guess that undermines our institutions. It was a very, very limited reference this morning, but it's worthy of noting to Dr. Patino's report, which says what it says. But it's important to note we have a specialist in the Maricopa County Attorney's Office, a deputy county attorney who for the last, since 2005, so 17 years, I hope that arithmetic is correct, has been doing the mental health / Rule 11 cases for our office. So not a physician, but an attorney who specializes in this area. Her name is Julie Rzinski. You may or may not have had exposures or encounters with her. But with regard to Dr. Patino, when she was aware that that report was issued and had a chance to take a look at it, what she explained to my colleague and myself just this week was that recently Dr. Patino was offered as an expert by a defense in a Rule 11 type contested hearing. And the Maricopa County Superior Court judge, I do not know that name. I can provide it to the board if the board members would like to supplement the record. But when asked the foundation questions, the sort of basic questions of what do you do, how long you've been doing it, what's your educational background, standard, what we refer to as Rule 702 matters, that Dr. Patino was not qualified as an expert and unable to give his or her opinion as to competency related to a recent matter in the Maricopa County Superior Court. Upon cross-examination, or it very well could have been voir dire, depending on the circumstance, I was not present, by DCA Warzinski, it was revealed that Dr. Patino did not have the appropriate training, did not qualify to give competency opinions pursuant to Arizona law, was not on the list. You may have heard Dr. Toma reference the list. One has to be qualified and sort of vetted to be able to give opinions regarding competency in criminal matters. And that's a sort of a clearinghouse way to make sure that, appropriately skilled folks are able to give their opinions. Dr. Patino was not approved for that list. And that, at least since 2005, Dr. Patino had no experience doing criminal competency matters. And I'm hearing from my colleague who must be watching live that this was in front of Commissioner Gilla, Gilla. I'll conclude, and unless anyone has questions for me, to the 2012 report from Dr. Toma with regard to the inmate's description of himself back in the 70s. And it's quite telling. Also, contrary to the advocates, the inmate described having toys, that his childhood was, quote, enjoyable, fun, carefree, end quote. So the picture that was painted of an inmate who was neglected and seriously abused, we're not suggesting that he had a perfect childhood, but the inmate himself in 2012, before he's facing the gallows, is representing enjoyable, fun, and carefree. But more importantly, the inmate explained why he preys upon women, stating, quote, I guess I dislike women because of her, end quote, referring to his mother. It is no coincidence, members of this board, that every single known victim of this inmate is female. The inmate explained that he was only 15 credits short of getting a bachelor's degree, which would put him in the highest levels, among the highest levels of educational background of inmates that we routinely see in the Department of Corrections. This is a direct quote from Dr. Toma's 2012 examination. Mr. Dixon stated that he had a problem, which began in 1978. He said that he had difficulty controlling his sexual energy. He had been convicted of sexual crimes related to this difficulty. When asked about the repeated sexual offenses, Mr. Dixon stated that they started when he was in his early 20s. He recalled, I used to get drunk after work. I'd get off work at around 10 and walk around Sin City. I'd get home and she'd be gone to work, referring to his wife. I hardly seen my wife. I was getting free booze at work, and explained how he was driving a tow truck to accident scenes and would find unopened bottles of alcohol. The first time I was walking around and I noticed a door was open. I went inside and the adrenaline was pumping. I saw a guy sleeping on the couch and I walked around his apartment. I took a calculator from the desk. After that, I started checking doors on my night walks. If they were open, I'd walk in. Once I saw a girl sleeping on her bed in her panties and a t-shirt. I didn't do anything, but that got me excited, end quote. So that is in fact the behavior, the attitude, the mentality of this inmate during the time he robbed our community of this lovely young woman. He further stated that when he was having sex with women, he got aroused from the dominance and the power. I like the idea of control or dominance, but I don't like to hurt. Handcuffs hurt, but straps don't. I used straps, end quote. The board should be reminded that the victim in this homicide case died with a belt, a strap across her neck. Does anyone have any questions?
I do have a question. Mr. Schneider, the 2012 evaluation by Dr. Toma was prepared, at least Mr. Dixon's team relayed to us that was prepared for the purposes of post-conviction proceedings, correct?
That's my understanding.
Were any of those pleadings or any of that post-conviction litigation, was any of it successful for Mr. Dixon?
Not to my knowledge.
That's my only question. Any questions for Mr. Schneider? Any questions? Okay. Thank you, Mr. Schneider, for your presentation. We're going to turn now to, I believe, Ms. Claes is next.
Good afternoon, members of the board. My name is Colleen Clace. I'm with Arizona Voice for Crime Victims, and our organization has represented Leslie James probably close to 20 years, at least from the time that we were in pretrial proceedings. As you make this decision today, I'm asking on behalf of Ms. James that this board also consider her rights under the Arizona Victims Bill of Rights to a prompt and final conclusion of this case. It's only the imposition of the punishment that that inmate Dixon is facing that will truly bring a conclusion to these criminal proceedings for Leslie James. Nothing about this case has been prompt or swift. Dina was murdered in January of 1978. Inmate Dixon remained free after that, and he committed a number of other sexual assaults after that time. It was close to 25 years that he was finally identified due to being in DOC for those sexual assaults. After he was identified in 2002, it was a 5-year wait for trial, and Ms. James will talk to you a little bit about this. 2008 marked the start of inmate Dixon's appellate proceedings, and that lasted 12 years. His remedies were exhausted in the spring of 2020, and we are now 2 years past the U.S. Supreme Court denying cert of his last petition. So more than 44 years have passed for Leslie James and her family since Dina was murdered. It's an extraordinarily long amount of time to wait for justice and to wait for punishment to be imposed. Ms. James's parents and Dina's parents, unfortunately, did not live to see the close to the criminal proceedings. And not only did Ms. James and her parents endure knowing what happened to Dina, wondering how afraid she might have been that night, and how much she suffered, they also sat through trial. They heard, again, how she was raped, strangled, and stabbed after death. They've suffered the emotional consequences. They have truly suffered the emotional consequences. We heard today from a member of inmate Dixon's legal team that it was traumatic for him to watch trial. I promise you it was traumatic for Leslie James and her family to watch trial. 2 instances from trial I just want to point out to the board. Because inmate Dixon represented himself, he was personally able to cross-examine one of his sexual assault victims. As he approached her, he greeted her by saying, and I'm not going to say her name, I'll just say her initial, but he greeted her by saying, "Well, A, it has been 20 years." At one point during the trial, it was the last Friday before the Christmas break, inmate Dixon turned to Leslie and Dina's father and called out at him and said, "Don't let the Grinch get you." This is not a man that deserves this board's mercy. I'd like to address a few other points. You've been presented with information in the materials submitted by members of the public. And in one of those submissions, it's asserted that the use of the death penalty against inmate Dixon raises serious issues of tribal sovereignty. In this case, in this state of Arizona case, that is an incorrect statement of the law. It is true that tribes do have the ability to opt out of the death penalty in federal cases under the Federal Death Penalty Act of 1994. And the site for that opt-out provision is 18 USC 3598. That applies to federal crimes. The express language is that no person subject to the criminal jurisdiction of an Indian tribal government shall be subject to a capital sentence for any offense for which is predicated solely on Indian country as defined by the U.S. Code in which has occurred within the boundaries of Indian country unless the tribal government body elects. This offense happened in Tempe, Arizona, minutes away from where Dina was a student at ASU. Inmate Dixon's crimes and punishment are governed by the laws of the state of Arizona. Dixon was prosecuted by the state of Arizona. He was convicted by a jury. His sentence has been upheld. He has been afforded every appellate remedy from a direct appeal, post-conviction relief proceedings, and federal habeas proceedings, and his remedies have been exhausted. The last point I want to address is a point that was made about the death penalty being unfairly applied. I don't think that's reflective of Arizona's death row. And this board can look at the website for the Arizona Department of Corrections, Rehabilitation, and Reentry. There are 113 people on death row, and 55% of those 113 people are white. The other 45% are comprised of various minority groups. Out of that, 4%, including inmate Dixon, are Native American. I'll close by asking the board to please consider and uphold Leslie's right to a prompt and final conclusion and her right to justice under the Arizona Victims' Bill of Rights. Grace for inmate Dixon is not warranted in this case, and we ask the board respectfully not to recommend a pardon or a commutation. Excuse me, a reprieve or a commutation. Thank you.
All right, any questions for this one? Okay, thank you. All right, so next we will hear, the order that I have it in is the victim is now going to speak.
Thank you. I'm Leslie Bowden James. I'm Dina's sister. I appreciate the opportunity to come and speak to you today. And other than the specific request I'm going to make at the end of my statement, I'm not going to restate all the information that I included in my letter to you of April 18th. You know, I've appeared before this board since 2010 regarding this inmate. I don't feel the need to repeat everything I've said to the board and on the record in each of those appearances. But the only thing that has changed today is that today's appearance revolves around the January 7th, 1978 choices and actions taken by this inmate to punch, rape, stab, and strangle to death my only sister, Dina. I've heard a lot of discussion today about reliving, revisiting the trial, the pre-trial proceedings. But you know, I would bet that I'm the only one in this room that attended every one of 42 hearings, every day of trial, and I followed and watched this inmate during every moment of those proceedings. I was there. If you have any questions of me about my perceptions and my experiences with this inmate, please ask. You know, today we haven't heard from any of the other women that this defendant, this inmate, has brutalized, terrorized, no telling what. I included at least those names of those women that I know about from reading every record on this inmate in my letter to you. I included their first names only. Some of them aren't even alive anymore, but we haven't had the opportunity to hear from them. So for me and for my parents, and for all of the women brutalized by this inmate, including his ex-wife, including his sister, for society, and most of all for my sister Dina, there is not one legal, social, or moral imperative for recommending reprieve or commutation of this inmate's death sentence in May 11th execution. I'm speaking to you today from my heart. You've probably seen much media coverage lately, and you'll notice that I have not chosen to be out there in the media like so many people are in this matter. But at any time, I'm really glad and willing to talk to you about Dina, about her life, and about what it was like for us. She was a fourth generation native of Arizona like me, and what it was like growing up in those days. One of the things I'm most grateful for is that I had 3 months with her in one of her last summers. And we rode the trains through Europe. And, you know, like sisters will do, we argued, we fought, we made up. And she was the one that was always supposed to be the one that got married, that would have grandkids from my parents. And she never had that chance to do that. And this inmate took that away from her and took her away from us. So I'm speaking to you today from my heart. And as he did about the last 10 times I've appeared before you and chosen not to appear, I'm not going to waste any words or breath on him or about him. Thank you for considering my request that my right, my constitutional right as a victim, for a prompt and final conclusion to this case be upheld. Thank you.
Thank you. We appreciate your comments. Were there any questions? All right, Ms. Bell.
Let me begin by simply responding to two of the questions that you had earlier in the proceeding. Instead of winging it, I want to actually give you the law. You asked, what is the standard for competency for someone to stand trial? Dusky v. United States, 362 U.S. 402. It's a 1960 case. The test is this, and I'm not winging it on something so important. The test is whether the accused has sufficient present ability to consult with his lawyer with a reasonable degree of rational understanding, and whether he has a rational as well as factual understanding of the proceedings against him. Commonly, that is having them identify the role of the judge, prosecutor, defense attorney, standards, burdens of proof, what is evidence, and so on. A follow-up question related to the ability to represent themselves or competency to represent self. It's essentially the same, and that's Indiana v. Edwards, 554 U.S. 164. And the court has recognized a mental illness-related limitation on the scope of the self-representation. The Constitution permits judges to take a realistic account of the particular defendant's mental capacities by asking whether a defendant who seeks to conduct his own defense at trial is mentally competent to do so. The standard leaves it to the discretion of the trial judge to understand the individualized circumstances of a particular defendant. And one of the Arizona State cases, capital cases, Gunches, affirms that. So I just want to make sure that we're all operating from the same understanding of the law, and that's the law. It was also asked earlier about guilty, accepted, insane, and the defense team provided an answer regarding what would happen. That was not factually or legally accurate. And in fact, if someone is found guilty, accepted, insane, as it's referred to now under our statutes, that person would go to the state hospital until he is in stable remission and, according to those practitioners there, not a danger. And as Mr. Schneider talked about, there are multiple murderers who've been sentenced to life, even after given life sentences, are then found to be in remission and then are released into the community. That's the law, that's the facts. That's where it's at. It is time. This has been decades in the making. As we talked about earlier, Mr. Schneider, obviously this is a board, the last stop as they referred to it, before potentially going to the governor regarding whether this is the appropriate punishment for this defendant, for this inmate, for this crime. Mercy. Where was the mercy for Dina as she laid in her home with a strap across her neck, being sexually assaulted, looking up and seeing Mr. Dixon's face, the last face she would see before she died? There were no attorneys. There was no appellate process for her. There weren't decades of celebrating birthdays, talking to mitigation specialists, going and watching court, watching TV, or what has he done according to the application to this board to better himself? I believe there's 3 words provided to you: reading and learning. What? For a man who has an IQ of 107, who is about to finish college, there's been a lot of revisionist history, and it's understandable. But the records do not bear out what they want you to believe regarding his mental health. And that, again, is for a different forum on a different day. But to suggest what has been suggested, that is why we gave you Exhibit 13, I believe it is. The report that was done recently, where Mr. Dixon is lucid. He fully appreciates the legalities, how he earned himself into the position that he's in. And he has an understanding of that. So there's no wishy-washiness regarding what the standards are. And again, that's for a different day. But to suggest that he is in a psychosis or is delusional is fantasy at best. On January 24th of 2008, Mr. Dixon had an opportunity. He had an opportunity to express remorse for what he had done. And I quote, this is what he told the jury as he stood up and looked them all in the eye. You don't see any remorse from me, period. Fast forward to August 28th of 2022. It's in your exhibit. His conversation with the doctor, Dr. Vega. You didn't see any remorse there, did you? The only remorse he had is that he murdered in the state of Arizona, as you'll read. Because if he had done it in another state, then maybe, just maybe, he wouldn't be facing an execution. Pretty lucid, pretty complex understanding of his situation. And pretty chilling too, quite frankly. During the closing argument, Mr. Dixon, who at that point, as you all know, had already been sentenced to multiple life terms, this was his argument. I have never been on death row. I've heard stories about it. I can do death row. But there's no problem for me being on death row. And this is the part I want you to hear what he said back in 2008. And you, as well as the public, know that the states are hesitant to execute. So it's going to be years and years and years down the line before they put me in a gas chamber, because back in 1978, that was the method of execution, nasal gas. He was suggesting back then to the jury, why bother? It will never happen, right? Well, here we are today. And who has been sitting here watching from the beginning is Dina's sister, Leslie, hoping that there would come a time where the jury's verdict would actually be honored. It is time. There are references throughout, and it's typical among the defense bar. These are very good people who advocate for the worst of the worst. They have an uphill battle. I do not slight them, but I would suggest this. Some of the approaches on these cases, in this case, are curious. At the beginning of today's presentation, there was a suggestion. We are not challenging the guilt of Mr. Dixon. Well, their exhibits betray them and their approach. Note the multiple cherry-picked excerpts where blame was shifted toward the boyfriend of Dina. Notice how they characterized in the application the boyfriend's role and how he was a suspect. They have woven throughout this application a claim of actual innocence. But at the same time, when it comes time to look you in the eye, then it's like, no. We are not challenging actual innocence. You know who else didn't believe this was a case of actual innocence? Larry Hammond. On August 7th of 2000, to a letter of Mr. Dixon, Mr. Hammond writes, I have your letter of July 16th, 2000, which was received by AACJ on July 25th and forwarded to our office on August 3rd. I have also looked at your evaluation form. The Justice Project is an all-volunteer organization with very limited resources. We look for cases of manifest injustice. Our first goal is to find these people who are innocent of the crimes for which they have been charged and to assist them in obtaining relief. Your case does not meet the standards of the Justice Project. There has been a suggestion, and Mr. Schneider touched upon this, so I won't belabor the point too much longer, suggesting that it was ineffective assistance of counsel to allow Mr. Dixon to go forward with his theory. In our system of criminal justice, American citizens have a right to put their fate in their own hands when facing the most serious of consequences and not trust their lawyer. There seems to be an arrogance among, I'll say, the bar in general, that because you're a lawyer, you know best. Well, Mr. Dixon, I don't think, quite frankly, a lawyer could have saved him from his own life decisions at trial. The evidence was overwhelming. There was no mitigation really to present. Family support? Well, when you molest your sister, that tends to degrade your family support. When your own mother states in a letter to the parole board, I'm afraid of him, I do not want him living in my home, those types of relationships that he created don't engender a whole lot of support from the family. So a lot of defendants often do not present mitigation because it may create more aggravation, quite frankly, than it's worth. I don't know why he didn't choose to do so, but we know that he had 5 years of mitigation being presented should he have wanted to do so. Many of the arguments have been recycled and rejected and recycled again before you. We live in the greatest country on earth with the best criminal justice system. Are there flaws? Yes. However, in this particular case, Mr. Dixon's constitutional due process has been honored and exhausted. The Arizona Supreme Court, the Maricopa County Superior Court, the Ninth Circuit, which, as we can all agree in the room, is probably the most favorable circuit court for someone sitting in Mr. Dixon's shoe, in his chair? And the US Supreme Court has reviewed this case. It is time. Callous, cold, depraved, that's who Mr. Dixon is. And now we hear the word mercy. It's offensive at best. Mr. Dixon gave Dina a slow death. She was in excruciating pain. The cruelty was absolutely unimaginable. Remorse, mercy by Dixon, where is he today? We would ask that you not grant any form of mercy in the form of commutation or reprieve in this case. It is not warranted. The just and true verdict, as spoken by our community members, should be honored, and his execution should go forward. Thank you.
All right, any questions for Ms. Dahl from any of my fellow board members? Okay. I think now is a good time for us to take our afternoon break. We will come back, it's 1:56, let's come back at 2:10. We'll hear a closing from Ms. Bass. And then we'll go into discussion and we'll have the vote. All right, we'll stand at recess now until 2:10. Thank you, everyone.
Sorry.
I'm sorry, not with me, I'm sorry.
Okay, would you kind of ask me some questions?
Sure.
Thank you.
Yeah. Well, I'm sure that there will be on. I just didn't want to make it because, you know, we have to be at the end because we said. So like I brought insurance and sort of if you were there, then have like crickets from 9 to 10. Have us be like, oh dang. Yeah, hopefully. Decently cool. Yeah, yeah, that's true. Oh, good. Yeah, yeah. Oh, and the church just lunch a little bit in my car. My work was so cool that it just like down. Yeah. Really? If you just order on yeah. I did rehearsal yesterday. And it's right next to my office. And yeah, we were. Yeah. And James couldn't stay. So you have it set up. Yeah. I was coming back to that, but yeah. It's on the north side. Videos, Pop Belly, the Habit. I came out so little lunch, but yeah. Well, I was impressed. I was impressed that just through the app and if you're like I mean, granted, I went there with my family, so that's a big order, but so I ordered.
Yeah, I know which one.
Two tacos yesterday. Cereal again, yes, and then I will support yes, I'm not, I know. Yes. Yes. Hi. And
Yeah, and usually, of course, you know, they would conduct it together. But when they decide not to participate, they couldn't.
Oh, yeah.
No. Yeah.
You know what it is, I'm saying.
Well, I think we're gonna start at 2:10. Yeah, so that was not bad.
Yeah, so I hope you don't think I'm being pleasant for fun. Yeah. Yeah, we understand. Yeah. I was 9-1 for that day. Yeah. Okay. Okay, cool.
We're shot. Yeah, yeah. I think I can do all the time, right? Like, so do I. I know, no, I think
All right, let's recap everyone. We will note for the record that we are now returning from our afternoon break to consider once again the request for recommendation of commutation of sentence or reprieve
to Governor Ducey for Mr. Clarence Dixon, ABC number 0388977. We had, prior to the break, just concluded with the state's presentation of its case, and we will now turn for the final word back to Ms. Bass. Go ahead, Ms. Bass.
Thank you. I also want to thank the board for your attentiveness today and for your thoughtful questions. I'd like to just briefly respond to a couple of claims that were made in the state's presentation. The first being that there has been a revisionist historical agenda as part of our case for mercy for Mr. Dixon today. And if I could, I would just like to point you to Exhibit 1 of the state's submissions, base number 001178 through 001179. And if I could just quote briefly, Tempe Police Detective W. Rogers, who in 1978 said in connection with Clarence's arrest and conviction for an aggravated assault and burglary. Quote, this is from the pre-sentence report. Detective W. Rogers of the Tempe Police Department was interviewed concerning the defendant. He reports that the defendant presented no difficulty at the time of his arrest. The detective states that in his opinion, sooner or later, the defendant will kill one of the girls he has accosted. He considers the defendant to be mentally ill, and his actions could not be that of a sane man. It is his recommendation that the defendant receive at least 5 years in prison, followed by probation with some type of mental health treatment, end quote. So I quote that simply to say that we are not revising history by talking about Mr. Dixon's mental illness at the time of the events in question here. I also just want to point out that the state's position today asks you to believe that our system is infallible and that the people and the actors in it are incapable of making mistakes, of dropping the ball. And I would submit that because our system is run by people who are well-intentioned but who are also imperfect, it cannot be infallible. You have heard today difficult testimony about the harm that Clarence inflicted on others as a young man. And there's no denying that that is the case. And there's no question that he was a profoundly damaged and disturbed individual who needed treatment for his underlying psychiatric illness. As devastating as his actions were, and as wrong as those actions were, and still are, Clarence was punished and continues to be punished for those crimes. He was sentenced to 7 life sentences for the 1985 sexual assault of the NAU co-ed, and he continues to serve that sentence. 2 days before Miss Bowden's murder, after receiving the psychiatric reports of Drs. Bentheim and Tuchler diagnosing Clarence with schizophrenia, the record shows that Judge O'Connor recognized that he was ill. She adjudicated him NGRI, and she ordered him civilly committed to the Arizona State Hospital for medication and treatment, and also to take him out of society. Those commitment proceedings never occurred, and the state has no answer for why that happened. Clarence is responsible for his actions. And talking about his mental illness and the failure to institutionalize him today is not an attempt to excuse his actions. It's not an attempt to minimize the harm that he has done. But it is important context for understanding how breakdowns in our system contributed to where we are today. You've heard about those breakdowns. They're not excuses, but those are breakdowns that resulted in Clarence making The fatal choice to represent himself when his lawyer, as you've heard today, failed to alert the court or to follow up on, in a timely way, his suspicions that there was something wrong with Clarence. In the absence of intervention, and as a result of Clarence's delusional choice to represent himself, and the state has not disputed this today, there is critical information relevant to the question of mercy that the jury never got to consider. That is a fact. You heard Ty Maybury talk to you about his conversation with at least one juror who, after the trial, came up to him and said, "Was there anything else? Was there more to this story?" They didn't have all of the information to assess Mr. Dixon's deservingness of the most serious sanction our society has to impose on someone. The jury didn't have what you heard today from Dr. Toma, who has explained Clarence's history of severe mental illness and his schizophrenia diagnosis, which the state has also not rebutted today. They don't disagree that Doctors Tuchler and Bentheim found him to be schizophrenic in 1977. That's also a fact. Clarence has spent 2/3 of his life at this point incarcerated. He is blind. He is physically frail. He is mentally incompetent, and his health is rapidly failing him. And I would point the board to the declaration of Tara Cuccinelli, who's a forensic nurse who reviewed all 3,000 plus pages of his medical records and catalogs his various physical pathologies. I also will just on this point say that the state has argued that Clarence's reference to himself as 145 pounds shows that he's not frail. He, perhaps is stronger than we are trying to represent to this board. But that reference to Clarence's physical weight is itself evidence of his delusions, because ADC records from April 12th, which we're getting every other day while Clarence is on death watch, show that he weighed 125 pounds with shackles on. So Clarence has no clue how much he weighs. He has no self-awareness. He has no insight. And so he's telling this doctor, "I weigh 145 pounds," and he's overestimating his weight by 20 pounds. In light of everything that you've heard today, strapping Clarence to a gurney and in the most premeditated of ways, extinguishing his life is not justice. It may be revenge, but it's not justice. These proceedings exist in addition to the judicial process for a reason. It's an opportunity for this board to consider whether or not to extend mercy. There are limits to how far an eye for an eye type thinking will take us as a society. And I think it was Mahatma Gandhi who said that an eye for an eye approach to life leaves us all blind. Because at the end of the day, what we decide to do to Clarence and to people like him who, yes, inflict harm on others, but who are also acting as a result of forces beyond their control, mental illness, psychosis, people who are damaged and who are disabled. What we do to them reflects on all of us. And so today we reiterate our request for mercy, and we ask that you recommend commuting Clarence's sentence to life in prison without parole. And in the alternative, we respectfully ask that you grant a reprieve so as to allow the proceedings underway through the courts to assess Clarence's mental competency to be executed, to be resolved before his life is extinguished. Thank you.
All right, thank you, Ms. Bass. So before the board goes into discussion, we did have listed as an agenda item discussion of the numerous written public comments that the board received. And so I just want to start by thanking members of the public for submitting those comments to the board timely. We received on Mr. Dixon's behalf literally hundreds of written comments from members of the public asking the board to recommend to Governor Ducey that his sentence be commuted or that a reprieve.
Excuse me, Ms. Mendez, you need to turn on your mic.
Oh, it is on.
Or turn it up. I'm sorry, I just have Catherine saying she's not.
Is that better? Okay.
Excuse my interruption.
No worries. Okay. Hopefully she'll tell you if it's, if they're still having trouble, then there's something wrong with the mic because it is turned on. So we did receive on Mr. Dixon's behalf hundreds of written public comments asking the board to recommend a commutation of sentence to Governor Ducey or in the alternative to recommend a reprieve for a specified period of time to the governor. I wanted to just note on the record some of the comments that I found particularly helpful. We read all of them. I'm not going to address all 450 comments. We also received a large number of comments in support of the victim, many of those from people who knew Dina personally, her family, and her friends. So all of the comments were helpful. I just wanted to note a few on the record that I found particularly helpful. The first one I wanted to note that I gained a lot from was the comments submitted by Ms. Ham. We all know Ms. Ham very well. There, at least pre-pandemic, there's a period of time where Ms. Ham appeared before this board on an almost daily basis. She's someone the board's very familiar with. She represents a lot of inmates in front of this board. She's had a number of successful inmate representations in front of the board. I consider her to be one of the premier inmate advocates in Arizona, if not in the country. And I know that we have a great deal of respect for her, all of us as a board. So I appreciated receiving her written comments. I'll also just note that sometimes she also represents victims, and she does that equally admirably. I very much appreciated the written comments from the American Bar Association. They submitted a letter to the board. And while brief, there were some comments and a video submitted by a Mr. Coach. I'm not sure if I'm pronouncing his name correctly. It's Koch, I believe. He notified us that he was the only death penalty case that was ever imposed by then Superior Court Judge O'Connor. And I found his comments very interesting and informative as well. But again, all of the comments, we reviewed all of them. All of the comments were extremely helpful. And again, we thank the public for submitting those comments. Any commentary from any of my fellow board members on the written public comments that we received?
No.
Okay. All right. Then at this time, having considered the information presented by both counsel for Mr. Dixon and counsel for the state, the board will be going into discussion. I want to just note on the record, it is important to refrain from interrupting the board during its discussion. At the conclusion of the discussion, I will, as the hearing lead, I will make 2 motions and the board will vote. A majority vote is required to grant the request that this board either make a recommendation of commutation of sentence or a recommendation of reprieve to the governor. In the event that the board recommends a reprieve to the governor, the board must specify the exact number of days for which the reprieve would remain in place. Ultimately, if a recommendation of either commutation or reprieve is made to the governor, the ultimate decision is the governor's decision alone. This board can only act to make a recommendation. The board is now in discussion. I'm going to say preliminarily as part of the discussion, I want to start by stating that I thought all of the council who were here today who presented information to the board did so in a very thoughtful, very complete and efficient manner. I want to acknowledge the significant work done by council on both sides. They were very well prepared and very diligent in their presentations today. I also want to say that, as board members, we're called upon to make some very, very difficult decisions. And never is that more true than in hearings of this magnitude. I will also just note that, I know these board members, some of them I've known for about 3 years. Mr. Franny I've known for a little over a year. He's the most recent appointee. But having known them each for a period of time, I know that each one of you is feeling the heavy burden of the gravity of today's decision. I want to, just as a reminder, remind my fellow board members that we are charged with the determination of whether clemency or mercy in the form of a commutation of sentence or reprieve is appropriate in this case. Many of the public comments that we received asked us to make a recommendation to the governor based on Eighth Amendment considerations, based on morality considerations. As one voting board member, I'll just state that when it comes to issues of constitutionality regarding the method of execution and whether these methods are violative of the Eighth Amendment, these are issues that have long been the subject of discussion and debate. And these are issues that are reserved for the judicial branch of government. And just as one voting member of the board, I wanted to make that comment. I'm going to share a few thoughts that I had during the presentation of each side's case. One of the first things that I look for in a case of this magnitude was there any manifest injustice in the case? And I know that Ms. Dahl quoted from a letter to Mr. Dixon from Mr. Hammond. Larry Hammond was the person who started, I believe he was the founder of the Justice Project, and he was someone who appeared before this board very regularly. He worked with my husband 30 years ago. He's someone I have a great deal of respect for. He's a really amazing, he was a really amazing lawyer and a really amazing human being. But I agree, just having reviewed the entirety of the record with what he told Mr. Dixon in that letter, rejecting his case for consideration to be represented by the Justice Project. I do not believe that there was any manifest injustice in this case. I also considered, particularly over the lunch hour, when we had a period of time to reflect, whether there was any doubt as to Mr. Dixon's guilt, and in my mind, there is none. And then I also spent a considerable amount of time reflecting myself on whether there was any doubt that the victim in this case, Dina Bowden, suffered immeasurably, and that her family suffered and continues to suffer to this day. And I wanted to elaborate on those thoughts a little bit further by saying, we did receive numerous letters and emails from the victim's family members and supporters, which make it very clear to me how terribly impacted they have been by this crime and how much the crime continues to haunt them to this day. And today we heard directly from Dina's sister about that long-lasting impact to her family. And I also noted that in the Supreme Court, in its opinion upholding the death penalty in Mr. Dixon's case, when discussing the aggravating factors that were found by the jury, the Supreme Court found, and I'm quoting here, quote, "special cruelty here. Dina surely must have suffered mental anguish while being raped, hit, and strangled. And Dixon should have known that the victim would suffer such anguish," and that's the end of the quote. So those are thoughts that I had just in thinking about the presentation that was made by both sides today's date. I also had some thoughts on the issue of Mr. Dixon's competency, and much of the time that was spent today was spent on this issue. So I kind of broke it down in terms of my thinking about it into two periods of time: his competency at the time of the trial and his present day competency. And so I just want to note that Mr. Dixon elected to represent himself at the trial after having a disagreement and a falling out with his counsel over trial strategy. The trial court determined that he was able to represent himself. We have numerous trial transcripts included in our packets, which we have all reviewed. for me at least, having reviewed the entirety of that record, contrary to the assertions of his counsel today and in sworn declarations that were submitted to this board, in my opinion, Mr. Dixon represented himself very well in the 2008 trial. He made clear arguments. He filed a number of motions on his own behalf. He proposed lucid theories regarding the evidence, including an effort to paint the victim's longtime boyfriend as the murderer. He submitted his own jury instructions to the trial court judge, and he clearly understood, at least in my assessment of all of the evidence and all of the information contained in the transcripts, he clearly understood the nature of the proceedings and that this was a capital case, something he referenced on the record a number of times during the trial and in his closing arguments to the jury. We also have, as part of the court records provided to us, some of the questions that were posed by some of the jurors during the trial. And I'll just relay for my fellow board members that that's interesting to have access to that, because that's not something that generally is publicized after a trial. And the way that it works is jurors individually submit questions, and then the judge has to review the questions and determine whether the questions are appropriate to be asked of the witness, for example, that they might want to pose the question to. And so we were provided, as part of the entirety of the court record from the Supreme Court, all of the juror questions, even those questions that Judge Klein determined were not appropriate to ask of any particular witness. And what I found, having reviewed those, is that those questions asked by the jury, these demonstrate that the jury, at the time of the trial, they gave very thoughtful consideration to Mr. Dixon's defense, which was that some other person, namely the victim's boyfriend, had committed this murder. But ultimately, the jury concluded that there was no reasonable doubt, given all of the evidence presented at trial, that Mr. Dixon was in fact the perpetrator. But I think that the fact that he was able to present things in such a cohesive fashion, and the fact that he was able to cross-examine the victim's boyfriend so well, and we read portions of that cross-examination, we have those transcripts. I think that's very evident when you read a lot of the juror questions, when they're asking specifically about Mr. Bain, the boyfriend's actions that night. It's very evident that that Mr. Dixon was able to make a very clear and effective argument on his own behalf. And then just turning to his present day mental state or mental competency, I noted after the lunch break, I wanted to give Ms. Bassett an opportunity to speak to this, if it was something that I was going to consider during the discussion. So I noted that Mr. Dixon has, over the last several months and even before then, submitted to ADCRR staff multiple, I call them grievances. I think that the actual term, I think DOC calls them requests. It's a request submission process that they have for inmates. And he submitted multiple requests, which make it clear that he indeed does understand that he is scheduled for execution. These grievances are part of his ADCRR file. They have been included in our packets. In these grievances, he cites to Arizona statutes. He cites to ADCRR policies. He proposes alternatives to or deviations from ADCRR policy. And again, he's able to advocate, just as he did in the trial in 2008, he's able to advocate very effectively on his own behalf. So to me, as one voting board member, this conflicts with the notion that he's incompetent to understand what's happening or why it's happening. And I also wanted to comment that just as recently as a few days ago, when he was evaluated by Dr. Vega as part of the ongoing mental competency arguments being made in the Pinal County Superior Court, he once again raised and argued, this time to Dr. Vega, that there was DNA from other sources in the case that was ignored, and that and once again engaged in, a form of victim blaming, indicating to Dr. Vega that the victim was someone known, and this is his quote, known to have had numerous sexual partners, and implying, just as he did in the trial in 2008, that this gave someone else a motive to kill Dina. So taking those grievances into consideration, along with the statements made very recently to Dr. Vega, taking all of this into consideration, to me, is highly indicative of a person who presents as someone who fully understands the crime for which he was convicted, and who understood then and understands now that he was sentenced to death, and understands the circumstances that led to him receiving the death penalty and the state's rationale behind its request of the death penalty in this case, and under the really horrific circumstances in this case. So I'm going to pause here with those initial thoughts that I had, and I'm going to ask my fellow board members for their comments and thoughts.
Did you want to go in an order, ma'am?
We don't have to go in any particular order, just whoever is ready can raise their hand. Mr. Kenya?
I'll try to keep it simple. Thank you, Ms. Mendez. I read the legal documents and transcripts, reviewed the facts, and listened carefully to the information provided to the board today. And I will say again that we are asked to make difficult decisions in the clemency process, and not everyone in the community will agree with my vote, and that's part of the job. But after taking in the totality, I am convinced that Mr. Dixon knew right from wrong when he raped and murdered Ms. Deanna Bowden. And I do not recommend commutation from a sentence of death for Mr. Dixon. Furthermore, I have heard nothing in the way of Mr. Dixon's remorse, rehabilitation, treatment, or recovery, which is to say management of his behavior, or again, effective treatment for his behavior. That would influence my decision to recommend some form of clemency to the governor of Arizona. And if I'm not mistaken, Mr. Dixon does not even have SMI status in ADC. So again, I am not in support of commutation. And I yield to my colleagues.
Additional comments, Mr. Johnson?
I agree with my colleagues, especially yours, Ms. Mendez, our board chair.
Yes.
I'm going to start out by saying there's no dispute of Mr. Dixon's guilt, on both sides, that there's no dispute that happens, no dispute that it was a heinous and horrible crime that was committed, and the death that was taken. I don't see him, and you commented about the requests that he's previously, just recently been making, that were written comments that were being made. I'm going to go back to the attorney, Mr. Garrett Simpson, who was appointed the case back in 2005, and he was appointed as the assistant. Then he went to the lead on that case, and his statement that basically he sat there, he interviewed, he went to trial with this person, and at no point did he see during that period of time that he was incompetent or there was some type of mental issues. And the mitigation specialist, Mr. Tyrone Mayberry, said that he had 9 cases at the time this was going on, and the standard for them at that time was 3 cases, that he was busy. But the idea that each one of them would say that it was horrible, the things that were going on. But I've had the opportunity to sit in on to 3 or 4 cases where the defendant represented themselves, and they also admit that it's very difficult for someone that's representing themselves to cross-examine or either do direct examination, regardless to what their mental status is, because of the court procedures. that are there, that they just can't do it. And if you sit in on one, when someone's representing themselves, it becomes very difficult for that person to be able to do that. However, I see that Mr. Dixon was more able to seem like to ask questions, to pose questions, to be able to represent himself, as opposed that when a lot of people who are representing themselves, they have their own idea of what they think is right and what they think is wrong. And they are very strong about it. And many times they have dismissed their attorney because the attorney didn't agree with what they agreed with, or they felt the attorney wasn't representing their interests because the attorney was really trying to represent their best interests, but they didn't feel like that. So I don't think that there was any injustice when he had his hearings, and the fact that he wanted to represent himself, I think that was his constitutional right that he had and that he wanted to do to be able to represent himself. I don't think it was an injustice. I think both Mr. Simpson and Mr. Mayberry both state that, the issue was not as much as him representing himself, but as much as what his idea he wanted to stand out and oppose, as opposed to what they actually wanted. So I don't see that as being mentally unstable for him to actually represent himself. I think that the fact is kind of alarming to me that Mr. Simpson would say that after he was cashiered out of the case, he says he's had other cases. That's the only case that he's ever been removed from, cashiered out of. That was his word that he actually used, that it was the wrong decision, that he made a mistake after he was removed from the case, that was actually his comments or statements that he was actually using. I think that at the time, Mr. Dixon knew what he was doing. He had his own plan and strategy that he wanted to implement, which is confirmed by both Mr. Simpson and as well as Mr. Mayberry, the mitigation specialist, as to what he wanted to do. I don't see him having received any injustice. I don't see him being mentally incompetent to defend himself at the time that he did. And still at this time, I don't see him not having the mental competency to understand what's going on, to understand why he is being sentenced and what's going on during these trials. So I don't find any reason to forward this case over to the governor's office for mercy or any combination of relief.
Thank you, Mr. Johnson. Any additional comments?
I'll just be brief without having to repeat everything. But when I first opened one of the binders, we had 4 of them, 4-inch binders. The first one I opened was the grievances, and I saw that they were written by an aide because of Mr. Dixon's blindness. So I compared it to his previous documents that he had written, and he had great penmanship. He articulated his thoughts well and clearly. And I had only heard in the news about the conflicting thoughts of his sanity and understanding and awareness. But reading those, he was very articulate and understood everything. Again, without having to repeat, he's quoting case law, he's appealing on their responses, and then just going throughout the cases. I read Mr. Thoma's interview with Mr. Dixon as well, and it was chilling about how he was creeping around looking for victims, going to unlock doors, carrying a knife with him, stealing. And I counted 4 victims that he sexually assaulted, and he instilled such fear that they fled the state. They didn't even stick around for prosecution after reporting it. And his first victim may have been his sister, who also broke down under interview. So without going on, I will honor the victims and the jury, and I do not favor reprieve or commutation.
Okay, thank you, Mr. Brennan. Any additional comments? All right, I will just conclude the comments, the discussion by saying I also wanted to add that, it is true that Mr. Dixon has conducted himself well at the Department of Corrections. He has very little in terms of any kind of disciplinary record, which does weigh in his favor. I, however, will also state that that did cause me to question if he is someone who suffers from delusions or hallucinations such that is being blamed for this horrific crime and the number of horrific crimes that he committed, because we do remember that Dina, while she clearly the crime that was inflicted on her was the worst of his crimes. There were many, many other sexual assault victims of Mr. Dixon. So it did cause me to question if someone suffered from a mental illness to such a degree that they would commit these really horrific crimes. It would seem to make sense to me that would also manifest in terms of negative behavior or conduct in prison, such that would lead to some disciplinary write-ups. So I wanted to note that as well. And finally, I just wanted to state I agree with my colleagues, particularly with Mr. Quinones, that what was really missing for me was any kind of showing of remorse for acceptance of responsibility. And I also weighed the very horrific nature of this offense and the senseless taking of this young woman's life. And all of those things lead me to believe that this is not a case for a recommendation of commutation of sentence to be made. Nor do I see, and I independently evaluated, but I do not also see any basis for recommending a reprieve of any length to the governor. I thought about the case that's now ongoing in Pinell County relating to his mental competency, and I gave thoughtful consideration to whether that might be a basis to recommend maybe a week or 2 week reprieve to Governor Ducey so that those proceedings can play out. But for me, just based on my trial court experience, in thinking that through, I'd have to have some basis to believe that there's a reasonable likelihood of success in those mental competency proceedings. And just based on the record that's before this board, that I can only imagine is or will be part of the record provided to Judge Carter Olson, that there really just is not a reasonable likelihood of success on the merits in that case. I'm not able to make that conclusion. And so I do not believe that a recommendation to Governor Ducey of a reprieve of any length of time is appropriate either. Do any of my fellow board members want to be heard or have any additional comments with respect to the request to recommend a reprieve?
I agree.
I agree.
Okay. All right. So the board having engaged in discussion at this time, I'm going to make 2 motions with respect to the request that the board recommend a commutation of sentence to Governor Ducey. I move that the board, having considered the totality of the information presented, that the board not recommend to Governor Ducey a commutation of sentence for Mr. Clarence Dixon, ADC number 038977. Is there a second?
Second.
Agree.
Agreed.
And I will note that the second was by Mr. Frenny. There's agreement by Mr. Quinones and Mr. Johnson. The board has unanimously voted not to recommend a commutation of sentence to Governor Ducey at this time. With respect to the request that the board recommend Governor Ducey a reprieve, I move as the hearing lead that the board, having considered all of the information presented, that the board not recommend to Governor Ducey a reprieve of any length of time for Mr. Clarence Dixon, ADC number 038977. Is there a second?
Second.
Agree.
Agreed.
And for the record, I'll note that Mr. Frenny was the second. Mr. Quinones and Mr. Johnson were in agreement. The board has unanimously voted not to recommend a reprieve of any length of time to the governor. And we will have our clerk, Kelly, note that vote tally in the record, and she will prepare minutes reflecting that vote tally. Lastly, the board thanks council for their thoughtful and thorough presentations, and also thanks those who participated in the hearing today, both as speakers and also the general public who submitted written comments to the board for consideration. Board policy prohibits further discussion following the board vote. Accordingly, this hearing is now concluded, and the board will stand at recess. Thank you, everyone.